Good evening. You ready to call this meeting to order? Marnie, would you please call the roll?
Councilmember Steve Friedman.
Hello.
Councilmember Deb Gillis.
Merry Christmas.
Councilmember Buddy Bender.
Here.
Vice Mayor Don Horton.
I'm here.
And Mayor Sharon Mahoney.
Here.
And we have a quorum.
Thank you. I'm reading my sheet and it says, Mayor asked someone to lead the pledge, Marnie. So would you please lead us in the Pledge of Allegiance, Marnie?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay. Any requests for deletions or emergency? Start with Steve.
Mayor, if I can,
Please.
I just want to have on a council communication, I wanted to just ask a question about where we're at with the TDR ordinance, so.
So you want me to put you down, Mayor,
wherever you-
Council?
It's your pleasure, yes, ma'am.
Okay, I'll do that. Dawn. Steve, go ahead, please.
I can save it for Mayor Council Communication.
What would you like? Well, you have to tell me what it is. What do you want
I
to?
want to talk about public comment period and council talking time.
Okay. Mr. Pender
No, I have nothing.
and Miss Gillis.
Can we delete the entire agenda? Oh, no, I guess not. Never mind.
Okay,
I do
and
have one thing.
1 second. I'm going to put a brief discussion about Angler's Reef under the mayor council communication, just so you guys know. Okay? Now, go ahead, Mr.
Let's
Pender.
rock and roll. It's the holidays.
Let's rock and roll. It's a
It's the
holiday.
holidays,
Okay. I don't know what that means, but okay. All righty then. So that's done. Don, would you like to start with the mayor council communications?
Yeah, thank you, Mayor. I just had a question on, I know that there had been discussion in many previous council meetings before about the pending TDR ordinance. And I know that was on the list of your big giant to-do list, and I just kind of wanted to have an update on where we're at with that, because the discussion that we had on Tuesday, that's going to help, lessen those numbers as we plug along, and so I'm interested in that.
Sure, absolutely. Yes, it's been on our list for a while. As some of you or all of you may know, the department has been extremely short-staffed. We've been down a couple staff members. We had somebody start last week, so we're getting her up to speed, and so we're getting ready to get back into some of those bigger projects now. I've been working on redoing my Gantt chart that I had presented to the previous council, so when I get that redone and fully established, I'll bring that back to this council. But my intent right now is to bring that to the LPA in February, and then that would be first reading in this council likely in March of next year. That's
Thank you
my
very
intent.
much.
Thank you. Steve, would you like to go next?
Yeah, I just wanted to talk to everyone a little bit about public comment period, especially tonight, since it's a quasi-judicial hearing, essentially, that I would encourage a little bit of leeway in terms of time. It's a lot of information that we're going to hear tonight, and for the public to come up and have maybe 3 minutes or 5 minutes to get all of that out is rather difficult, as we also, in the same vein as council, should be as responsible as we can to be as short and succinct to the point, because I'm sure we all noticed a lot of people leaving the meeting during some of the filibustering that was going on at the last meeting. So I would encourage maybe even for ourselves to hold ourselves to a shorter time period to get the point out, and always be able to come back around and speak again. You're not just limited to that, maybe as the public is. So for tonight, I would like to see either some leeway or maybe additional time given to the public when they speak, so we can also have an opportunity to question them and their statements, and that for us going forward to just try and keep it as short as we can.
I don't know if, John, you want to chime in here, but I agree with you. Wait, let me finish. I agree with you that we have to also be respectful that there's 5 of us up here, and everybody wants a chance to speak, so try to be mindful about the amount of time we each take. And I agree with you that it was a lot going on Tuesday night, so thank you. Go ahead,
But let me remind everybody,
speaker, Mike.
on quasi judicial, they have as long as they want. There's no 3 minutes on that.
That's what I was going to
That's
say
what
too.
I
That's,
asked you. I
thought it got-
quasi-judicial, it's testimony.
But that's not correct. It's a 3-minute, 5-minute, and
3
quasi
minutes,
as well.
5 minutes? Okay, I thought maybe we must have changed it then, but.
And again, I would appreciate it if you guys up here raise your hand to speak, so we don't speak over each other, okay?
Yes, ma'am.
Okay. Steve, are you done? Okay. I asked Frank to put up something for me. I've been working with the Homeowners Association at Anglers Reef on Winley Key. They have a problem with parking. If I can get that up there. And again, this is just for you guys to all start thinking about. I appreciate any input you may have. Part of the problem with Anglers Reef is it's really tight inside there. And so as a result, we get people with cars and their trailers in the medium, what I call the medium, between the old road and US 1. So we came up with the trailers would go to be rented or pay rent to be at SD Marine, so that would take care of their trailers. And then if you see, we have the hammock with 3 parking places, some hammock, 3 parking places, and my thought was that the Homeowners Association would be responsible for those parking places. Fee and the care can all be worked out. I agree with Mr. Horton about we do need some paid parking, but there's some areas that it would be impossible, and to do paid parking when someone's at a residence for like 24 hours, unless 3 in the morning they want to run downstairs with their quarter. So that we may want to do a parking study for the village to see what would work. I had talked to Jennifer about that, and I don't know what her thoughts are, but this is not set in stone. I'm open to anything, but we have to address the problem in that section of Winley Key. Because if we don't do something now, it's just going to go back to the way it was. So this is my suggestion, and I don't know if Scott is here. He's the president of the Homeowners Association. If he'd like to say something? Sure. Oh, is that okay with everybody?
Yeah, so.
Okay, come on up. Well, on the podium. You can come up here if you want to.
Hi, I've been in Anglers since 2010. Since 2010, we've always gotten to use, look, Anglers Reef, there's homeowners that live there full time. There's homeowners that it's their vacation home, they use it as a vacation home. Some people do vacation rentals, and they also use it as their vacation home. The major problem with what we've had is the homeowners, like myself, right? My driveway fits 2 cars, and when, like Thanksgiving, my kids came, my in-laws came, there's nowhere to park. It was a nightmare, and it's not just me. I'm president of the association, so I get all the phone calls, and I get at least a dozen phone calls a month since July, since we stopped parking there. The trailers aren't a problem. We've got that's easily worked out. But the automobiles, you can't expect somebody to park and take a freebie, to park the car and come over. And it's just, you want to take your buddy fishing for the day. There's just nowhere to park. So, what was taken away that we've been using for over 15 years, we'd like to somehow get it back. And I agree, it looked horrendous out there before. And we're all excited that maybe we can make something happen that looks nice and useful. And, we would invite, what we'd like to see is something just for us in our section, whatever other sections they want. And we're happy to pay a monthly fee to maintain and take care of it, which can be worked out.
Okay, thank you.
Thank you.
Again, this is not set in stone, but it was an issue, and I got with Scott, and we came up with what this could look like and could be. So I'm open if Jennifer and John, the legalities, and what you guys feel about this. So, well, Deb's raising her hand, so let me, go ahead, Deb.
I'm trying to follow the rules.
Oh, well, I said, go ahead.
So it's amazing. I think this is a great idea because I actually suggested that when the council put it in place, because of the water line workings, that they couldn't park there anymore, and then it would continue on, that something come about, we find a lot, we try to help them find a lot, something, because of the fact that we've used that parking in this village for, I don't know how many years. And it's probably prior to Anglers Reef, we were using it too. So I think it's a great idea, and I'd like
Thank
to
you.
see it move forward.
Thank you. Don?
Yeah, I like it a lot. I'd like to see us put pervious pavers in there.
Whatever
Yes.
you want.
So that we,
That's why
you
it's
know,
here.
so we can take care of our good stormwater management in that
Sure.
area. The hammock and the trees are wonderful. I think it's a great idea, and I think it's a great test area for us to see how it would work through the rest of the village. I like it. I like
Thank
it
you,
a lot.
thank you. You guys have anything to say? Turn your mic on and speak.
We'll turn my mic on, yes, ma'am. What about FDOT? Have we talked to FDOT? I mean, Jennifer.
This is just the first step. So
Okay.
I wanted to see
We just got- yeah,
how
because
everybody
that's
feels.
FDOT
And
right away,
John and I
so.
have talked about it, and Jennifer. And, you know, this is just the test thing to see.
Okay.
And there's all kinds of hurdles we have to go through. But I wanted you guys, of course, to have your input, suggestions. I wanted Peter to look at it, AJ to look at it. And,
Okay.
you know, we could form something really good here.
Okay,
So-
but I think, Jennifer, wouldn't you say we need to run this by FDOT as well?
That's village property, it's village right-of-way, so I don't know, I mean, we could certainly run it by them, but I don't know that they have any
Oh, good.
approval authority over
That's
it.
fine, no, that's fine, that's what I'm saying, it's better, hey, it's better that we ask them and we don't need it, but, you know, we need to be on the good side of FDOT.
And Steve, do you have any thoughts?
You're just asking that this is the beginning of the process to try and get this
Yes.
going?
Yes.
Yeah, okay, I'm fine.
Okay, so, go ahead, Deb.
So I was just going to make one more comment. I think what you're thinking of is that right away there, that section is probably split. The outside edge is FDOT and the inside was village.
So I guess then I would ask direction from Rob and John and Jennifer to move on forward with this, okay?
Yep, yeah, I mean, we understand the council would like us to move forward, and the three of us will work forward and hopefully be able to bring a resolution and solution back,
Great.
Shortly.
Oh, I'm so happy. Oh, good. Okay, thank you very much. Village attorney and. Do we?
No, this is just a discussion item, and that was again why we moved public comment to after this, so they could incorporate anything they
Okay.
wanted to speak
And
in
you
general
yelled
public
out
comment.
public comment. Don't do that. So, village attorney, village manager communication, please.
Did you get the talk, Steve? Did you talk about what you wanted to talk about?
I'm sorry, that's me. I'm like, I don't have anything. So the one item I have is tab A on this. This is, you may recall back in August, the previous council had voted a second reading approval of the temporary moratorium for administrative relief. Upon the signature of that ordinance, we rendered it to the Department of Commerce. Commerce then asked for a phone conversation, which I had with them in October. They were prepared to appeal that ordinance. They felt that it was not compliant with our comprehensive plan. They asked us to withdraw the rendering so that we could discuss their issues and then come up with a path forward. I questioned why we were able to do a market rate moratorium and we weren't able to do an administrative relief one. And they noted that the village's building permit allocation system section has a phrase that says unless otherwise exempted by ordinance, and the administrative relief one doesn't. So I think that's where they're saying it's not compliant. I have not had any additional conversations with the Department of Commerce, knowing that the council election was coming up. I wanted to wait and see before we put any work into moving this forward. I wanted to get the council's opinion as to whether or not we wanted to re-render it as is and see what Commerce does with it. You want me to work with Commerce and come up with something new, or do you want me to just withdraw it completely? Those are pretty much the three options we have.
Okay, does anybody want to express how they feel?
Yeah, I do.
Go ahead.
Deb, did you?
I do.
Well-
I can wait. He's got his mic on. We'll let him go.
Okay.
I just said, go ahead, Don.
You know,
Go ahead. No,
these
go.
people that are stuck in
Limbo.
limbo, in this administrative leave, in good faith, they spend a lot of money to get their surveys and their plans and make an application, go through the review process. They've waited 4+ years if they're coming to us for administrative relief and seeking administrative relief, and I just never agreed with the decision to put a moratorium on this and stick them in limbo. And I think they need to, I think we need to not have this moratorium and let these folks work their way through the system like they were told they would work their way through the system 4+ years ago, and at least seek relief here in front of this council.
Okay, Buddy?
Well, not to mention that, Don, only, they paid a $1,500 fee after waiting for 4 years,
That's right.
okay? And then we go to try to put a moratorium on them. It's not, and building costs have risen, so what it would have cost them, 4 years ago is gonna cost 25% more today or more. So, I agree. I think they should. Our system is, we told them what to do. They followed our rules and our guidelines and our protocol. And I think it's, now even the state coming back to us and appealing it and saying we can't do that. So we need to follow our guidelines. If we tell somebody something, we need to stick to our guidelines. That's all I have to say.
Deb, would you like to go?
Yes, sure. Actually, I have brought this up a couple times since I've been back. And this was in front of me when I was on LPA, and I probably was one of the few that, I don't remember how the vote was, but I voted that we should not be doing the administrative relief. The other categories is a different idea. These people have waited in line. Maybe there's other options that we can give them. That's what part of administrative relief is all about. But I don't think we ought to put a moratorium on that. I'd like it to just to be gone away, dissolved.
And Steve?
Isn't already a moratorium on this? Okay.
Not on this category.
Okay, so we're just being asked to, I thought we were being asked to lift it or to
If we wanna-
extend it.
What is your feelings on that?
No, I agree with council. I'm fine with
Okay.
it.
So what I'm
He's
asking,
confused.
what I'm asking, so there was one voted, but before it can take effect, it has to be approved by the Department of Commerce. The Department of Commerce has said they will not approve it as it's written because they don't believe it's compliant with our comprehensive plan. So I haven't had any further conversations with them yet, but what I'm guessing they would request that we do is do an amendment to our comprehensive plan so that it could be compliant. So before we went through that effort and that work, I wanted to find out from this council, do you want me to do that? Do you want to re-render it as is, or do you want to withdraw it completely and not have a moratorium at all?
Thank you for that, yeah.
I think we're in agreement to withdraw it, I believe. Go ahead.
It's a perfect example of Big Brother watching Big Brother, and when somebody says you're making a mistake by doing this, if a mistake is made, Big Brother definitely is going to let us know, especially when it's part of our comp plan. And that's what they've done, is responded and said that last council really shouldn't have done what they approved, and they're letting us know, do you want us to appeal, do you want us to orc it, or do you want to just forget about it? And I think we just need to forget about it.
Okay, so is that good, Jennifer? You understand?
Do you
John, do you
need-
have anything?
I think we would want a formal vote to withdraw.
Okay.
right?
I'll make a formal motion to withdraw the,
Oh, never mind, John says it's not necessary.
Okay. Oh, Deb, that was so good, too.
darn it.
Yeah.
Okay, do you have anything? Rob, did you want to say something? Okay.
Do you need a second? I'll second that. If you
No,
want it worded different.
Do
Yeah,
you
no, I don't-
need-
I don't
Do
think
you
it's-
need just a motion, or do you want to?
I don't think it's necessary because
Okay.
honestly, like Jennifer and Don explained, the options are, do you want to fight commerce? Do you want to change, bring it back, or do you want to just leave it be? And what we're hearing is leave it be. Don't, we're not authorizing you to fight commerce through litigation. We're not authorizing you to do something else, so I don't,
As long as you think you got what you need from us.
yeah, I think so, yeah.
Okay, good. All right, moving on. Public comment. Marnie? And this is stuff that is not on the tabs, and it's what you want to talk about. So Marnie, who do you have?
Well, we did have Mr. Epstein, I don't know if he wants to speak again about anything else.
Just wanted to say thank everyone.
Okay, great. Next up would be Ty Harris.
Come on up, Mr. Ty.
Good evening, Council. Ty Harris with the law firm of Ty Harris, PA, 110 Plantation Shores Drive, Islamorada, Florida. Two things, just quickly. One, thanks again for giving staff direction on trying to solve this parking and beautification issue on Windley Key. It's been going on for too long, 15 years. But it's also not fair to give people 30 days notice that we're not going to let you park there after you've been parking there for 15 years. So I really appreciate the direction you gave to staff. Second, everybody up here, when they were running for a seat on council, supported affordable housing. I have a affordable housing project of 42 units for the property just south of Fisher Inn. We're on our 4th round of comments. We're getting very close to the end. We thought that we would be able to use Live Local, but after doing research, discovered that, and you may not know this, but less than 20% of Islamorada has commercial or industrial zoning. In fact, it's closer to 15%. Until you hit that 20% threshold, you can't actually use Live Local. So that has now put us back into the category of the early out allocations. And the early out allocations have a prohibition against developing in a V zone. This property is in a V zone, even though the plans show that it's clearly going to be elevated 12 feet and the only thing on the ground is going to be parking. But Jennifer and I have discussed it. We're going to need to make a comp plan and a zoning change in order to finish this project. And I would respectfully request that you expedite that, because this thing just going to sit, and as Don mentioned and council's mentioned, construction costs just keep going up. And that's one of the 2 barriers to actually doing new affordable housing in Islamorada. Cost of property, cost of construction. I thank you for your time.
Thank you, Ty.
Thank you. Marnie, who's next?
Van Keenhead.
We discussed the Angler's Reef problem, and the staff, Mr. Cole, said that the landscape project was going to be from one end to the other. And the problem is that when the planning for Angler's Reef happened, that was the failure. There was too much density and intensity in that plan that didn't. They made their own problem, and the trailers and the cars there. I would like to have been able to discuss this when we were discussing it, and not have to waste my 3 minutes going over something that needs to be talked about in the general sense. This is something that's serious, and it's going to cut into having a hammock from one end of Windley Key to the other down, which is what we were promised. So you're going back on that and taking the part of the Anglers Reef people. I understand they've got a problem, but their problem was made by their planners and by the people that sold them their property. So if they have to go buy another lot to park their cars on, that's not on us. Shouldn't be on us. We're going to have trouble in the next 2 years. It's pretty obvious from the last meeting that we're going to have 3-2 votes. And instead of Larry, Moe, and Curly, we're going to have Don and Debbie and Buddy. And the Three Stooges of the Concrete Coalition are going to rule what goes on in this room. And I don't feel that we're going to be in a position to save Islamorada if everyone here is pro-development. And the people of Islamorada who elected the people to this council are just as much to blame as the people who are pro-development that are sitting up there right now. And we're going to be into a discussion about TDRs, which we should have an in-depth discussion about that, but we should have it when Able Cities East comes forward with a comp plan and with a LDR suggestions, because 25 years ago, when they came out with TREs, I said the best thing to do with the 43 units from Plantation Yacht Harbor, the 400 square foot motel rooms, was to take those building rights out into the middle of the field and burn them, because you're going to make a can of worms opened up once you do that. And sure enough, 25 years later, we're still taking Creekside Inn with 400 square foot rooms, moving them down to the Islander, and we're increasing the density and intensity of Islamorada by 50 rooms. And those are not going to be affordable housing.
Thank
So-
you, Van. Time's
Yeah,
up.
thank you very much. I'll be back.
I know you will. Next, Marnie.
Joe Wishmeyer.
Yes, Joe Wishmeyer, Plantation Key. Mayor and council, it was very disheartening at Tuesday's meeting after all the concerns that I brought up about the legality and conflict of interest that the village attorney nor any council member asked for clarification on those issues. I guess that means that Mr. Quick feels that everything was okay and that even an ordinary citizen can put an item on the agenda. These decisions could lead to further scrutiny by residents. Tonight again, you will be making decisions that will affect this community for decades and generations to come. We all sit here and listen to council members talk about the good old days, growing up with pristine reefs, fishing and diving. Compare those days to the overdevelopment, traffic, and declining reefs and water quality. You should look back and decide if even more development is going to benefit our kids and grandkids if we continue in this direction that we are headed. In only the second set of meetings, this council has already reversed decisions discussed and voted on by the previous council and more than doubled the number of permits requested by the village. Tonight, you will also be hearing items heard and denied or deferred by previous council. The decisions that you make tonight will let all residents know if you are going to look out for and protect our fragile ecosystem and environment like you promised in your campaigns, or bow down to developers and contractors. Your main concern should be workforce housing, like apartment buildings, not affordable housing, which is not affordable for most of our workforce, and have rent controls on them as well. This would benefit all businesses that now either cannot find employees or have to come down by bus from Miami or Homestead. Why must you make these drastic decisions now instead of waiting for our new comp plan and LDRs to be completed? Decisions made now may not even be in compliance with the new plans. Putting a moratorium on, or at least defer major decisions like the Islander, Creekside Inn, and others would seem to be the right thing to do at this time. Your legacy and the future of our community is in your hands. Last, council spoke about losing some properties on our tax roll so that all of our taxes would go up. Yet you let places like Legoland, Sun Country, pay $80 a year per lot in taxes, while the rest of us pay much more than that, our fair share. If you cannot fix this problem, then maybe you should get your lobbyists to look into this, because it is costing us millions of dollars a year, whilst they still want the support of all of our services like police, fire, and other village services paid for with our tax dollars. Thank you.
Thank you very much. Marnie?
Next is Sue Miller.
I came with bills on tonight. Sue Miller, Lower Matacumbe, representing the Islamorada Community Alliance. This agenda tonight is 719 pages long. I've been attending most council meetings since we incorporated over 25 years ago. The agenda tonight has some of the most difficult to comprehend and challenging complexities for you to judge. I attended 18 public hearings when we created the Village Comprehensive Plan originally, and I know it pretty well. But in order to understand and judge tonight's agenda items, I had to go back to that aging comp plan and the LDRs to reread the zoning requirements, the TDR regulations, and site plan approval. Yes, they are in desperate need of updating, and they are extremely confusing. 719 pages. What's with all the reports, like for affordable housing, more than a decade old, used by the applicants tonight? Times have changed, and with it, the statistical information to make educated decisions. As members of council making critical decisions tonight, I hope that you also studied the village regulations. Even the professional planners can miss some of the intricacies of our regulations and some of the out-of-date regulations and conflicts that pushed us to plan a total review and update by an outside planning agency. The decisions you make on issues tonight must be carefully considered to assure that the rules are followed. The process is fair not only to the applicants, but also to future applicants and prior applicants that all deserve the equal treatment according to the regulations. We hear about the applicants' property rights, but remember, their neighbors and the entire village are also impacted by your decisions. We also have property rights and the right to quiet, enjoyment, etc. Is this agenda tonight fair to you on the council? Is it fair that these public hearings were delayed for months and now you have 719 pages to review just a month after you were sworn in after a contentious agenda 2 days ago that required considerable amounts of your time, thought, and research? Did you have time to give these items a fair analysis? The staff has had since April of 2022, when the Islander application was submitted to get us to this point, 4 new council members and a couple new managers and virtually a new planning department since that application was first submitted. The code says the staff review is to be done in 30 days and then presented at the first council meeting after the review is completed. It apparently took a few years for the review, and now the council is given a couple days to absorb the details and either rubber stamp or do a serious review itself. The village code says 1 or more public hearings are required. Perhaps in complex issues that could have such serious repercussions, a second public hearing should be considered. Alamorada and all of the county has serious concerns as to evacuations, day-to-day traffic, a struggling environment, affordable housing. Public hearings are required when a project could have significant impact on a community. Never rush through your decision-making without careful examination of the impact. Thank you. Your job is certainly a tough one tonight. Thank you.
Thanks, Sue.
Buddy, did you want to say something? Okay, all right, go ahead, Marnie.
We don't have anyone else.
Okay.
So
Mike.
I wanted to just address what, oh, my mic won't come on now.
That might be on purpose.
There it is. All right, here we go. Thanks, Frank. Just so the public knows, when Van's talking about Anglers Reef, the former property was Tropical Reef Hotel. The Minjas owned it, all right? And there was 52 units that the people in Key West bought, and they did 1 for 1, and that's how they got that. They built the Anglers Reef. There's already 52 units on the property. It was Anglers Reef. It was Tropical Reef Hotel is what it was. It was the units plus a couple houses they had there. All right, so that was done many years ago. It was Cortex out of Key West, the group that did that. Anyways, you know, if somebody wants to look, they can find out 52 units was what they bought. Can I respond to that, Ms. Mayor? No, I'm just letting the public know. Mr. Mulick represented the people at the time. So I know because I was in the meeting when it all got approved. All right, so.
Can I respond to that, Ms. Mayor?
No, sorry. We don't, well, let me just say this. All I did for Anglers Reef was bring up a thought. You'll have time to make your comments when it comes back to us in different shapes and forms. So nothing's a done deal right now. So you'll have time. No, can we just move on, please? Are you done?
Yeah, I'm done.
Okay,
Yeah.
we're done with that.
Yeah.
All right?
I just wanted the public to know.
I know you did. Okay, so, Mr. Wishmeyer, I said I'd let you speak about the meeting schedule change, and I'm going to be a person of my word. So would you like to? Yes, I would. Before we do it?
And Madam Mayor, if we're opening it for Mr. Wishmeyer, we'll open up for everyone if anybody else would like to speak
100%.
to.
Yes, Joe Wishmeyer, Plantation Key. Just as a reminder,
Hang on, so are we opening that tab?
Yeah, look, we're moving on
Is
to
that-
the
Next.
motion from, the motion section from
It's a
last Tuesday.
continuation.
Yeah, I
of
know,
our
I
meetings.
obviously I didn't get the printed out new copy,
Yeah,
sorry.
it was,
Go ahead.
Oh, it's
Capital
okay, go
I
ahead.
printed a copy for everyone.
Go ahead.
And Ms. Mayor, before I start, if you could remind everybody what this is about?
Oh, this is our schedule change. I guess there were some conflicts for next year's schedule. Yeah, on Tuesday night, there was some scheduling conflicts, so they gave us the days that were an issue and asked the five of us to come back with when we want to move things
Okay.
to. Simple as that.
Yes, Joe Wishmeyer, Plantation Key. Regarding the schedule for next year, I would like you to seriously consider going back to meetings 2 weeks apart. I remember that they used to be like on every second Tuesdays and Thursdays. I have brought this up in the past when there were 800 to 1,000 pages in the agenda packet. The amount of staff time required to research and put together that big of packet takes away from other duties and responsibilities. For council members to review and properly research that many pages in less than a week is unreasonable. This week's agenda is almost 900 pages again. Since council members are required to live in the village, I don't see why we can't, and it would make more sense to have 2 weeks apart, giving the public and council more time to review. Before 2 extra long meetings within 2 days is asking too much. Please consider this and correct this problem on behalf of staff, council members, and village residents. Thank you.
Thank you, Joe. Does anybody else want to comment on our meeting dates before we talk about it? Go ahead, Van. It better be about the meeting dates.
Absolutely.
Okay.
I've stood here several times and pointed out the fact that in the first charter of this village, it was put in print after much discussion and back and forth that the first and third Thursdays of every month should be the meeting for our village. So, which is what Mr. Wishmeyer just said. I'd like to follow up and reiterate that the first and third Thursdays are something that the village population can hang their hat on. They can look at the calendar and say, well, there's the first Thursday, here's the second Thursday, and those are the days that we're going to have a meeting. And because the staff chose that it was too much trouble for them to set up and break down twice a month, they went for every 3 weeks, which broke up the whole continuum, which broke up the entire system that people had been hanging their hat on for years. And we keep turning up with these multi-hundred pages of fluffed up agendas that aren't necessary. If we would go by our original charter, which was the reason that it was done was a good reason, and it worked for years. And suddenly we're doing a Tuesday, Thursday, and we're doing all of our land stuff on Thursday, and this is not kosher. This is not what the village set out to do, and it's proven to be a real burden on the public to understand and know what's going on out of a 700 to 900 page agenda. And Mr. Wishmeyer also pointed out, it's not fair to you to be crunched like that. In other words, these agendas are packed and stacked, and they're done with something for a reason. And the reason that we should have more meetings, and the meetings that were originally designated by the original council and put into the village charter. But, you know, the charter was changed because of a waiver. Now, any three of you can make a waiver. So they made a waiver that we're going to do it Tuesdays and Thursdays. You know, we can do it once a month. You know, it's just untenable that you should choose the fact that you can make a waiver. You can make a waiver to go from 104 units to 250 units, you know, but it takes 6 months, supposedly in the law, before that is revisited. But if you have a waiver, you can do it next week, which we just did. And so, you know, we are not being well served by people with an agenda making waivers and getting around the law with their waivers. Thank you.
Thank you. Anyone else, Marnie?
No one else has signed up for
Well,
this.
I'm not going to let the staff take the fall for this. It was me. I'm the one who moved the meetings, suggested moving the meetings to Tuesday, Thursday, to give us 3 weeks off in case we wanted to do a workshop within that time or something else came up. We have a lot of other business just besides the meeting. So I guess it was me, and the council at the time agreed with me. So here we are again now with, if anyone wants to change it, I'm open for it. But if you want to leave it as it is, let's move forward with changing the dates.
I don't want to change it, but I just wanted to comment is that it's very consistent month after month of when the meetings are handling. So, you know, the 3-week was an idea of we were having meetings every other week, as Van was alluding to, and we thought that they were very short meetings for the most part, and so we wanted to spread it out, and we just couldn't bring ourselves to do only one meeting a month, one night a week, so that's why we went to 3. This 2 in 1 week is working pretty well, so.
Anybody else?
Yeah, I mean, I see both sides of the issue, and my situation is similar to what Ms. Miller spoke about in terms of trying to gather all this information in such a short amount of time. Very, very difficult in such complex situations like what we're going to hear this evening. Also, I've already seen some conflicts that I'm going to have for some meetings when we have them Tuesdays and Thursdays because I'll be out of town. So if there is that one a couple weeks later, then I might miss one and not both, and so I'll defer to the council here and how they want to schedule it, but to me, I could go either way.
Don?
I'm happy with the schedule the way it is.
Buddy? Okay. Do we need to vote, or are we good to move forward? Okay.
The schedule's set by, that format is set by resolution anyway, so.
Okay. All right, so does anybody have any suggestions, or Deb and I spent a few minutes. Deb, would you like to read the dates?
Sure.
That we suggested, see if you guys are okay with them?
Sure. So we have 3 sets of dates that it looks like there's conflict. And Steve, if you have a week that's a bad week, you just need to let us know, and we can try
move the
to
whole
adjust
meeting.
that week.
We can move the whole
Okay.
meeting.
So the first conflict was in March, and that, I believe that's the League of Cities?
Florida Keys Day.
Florida Keys Days, I'm sorry, I've got the wrong one on the wrong month. So our original schedule says the 11th and the 13th. If we move it to the 18th and the 20th, then that leaves the Florida Keys Days available for us to attend. We would travel on the 12th, I think it's the 13th and the 14th, maybe the morning of the 15th. So that, it just moves it 1 week farther into the month, so that would be the 18th and the 20th.
So you're moving 2 days on that?
Yeah, both of the meetings. Is
Okay.
that a problem?
No.
Moving it to all in
Just
1
trying to
week?
keep up with you.
Okay.
So
It's
March-
just a suggestion.
March what, 18?
18 and 20 instead of 11 and 13. Does that work with your schedule?
That's better for me, yeah.
Oh, good.
Okay,
Okay.
so
And if you have an
perfect.
issue, just tell us.
Well, we're going over it
And-
now, so.
Okay.
Yes.
Okay.
Let us know.
Now,
Okay.
August, Deb?
The next one is August, and I believe that's League of Cities, right?
League of Cities annual event.
Yeah,
Annual meet-
so the same thing occurs, it's towards the end of the week, and so if we move that one a week earlier to the 5th and the 7th, that allows us to do the annual event, and in the following week is when we start into budget work. So therefore, you know, it gives us a little space in between to do a couple other things in our lives too.
My God, just give
So-
me a date.
I'm sorry?
Just give me a date.
Okay, well, sorry. August
She said the
5th and
7th,
7th?
Don.
5th and 7th.
Okay, great. Let's do it.
Okay, and then in November, Election Day is the 11th. How about if we move that one to the 10th and the 13th? That's a Monday and a Thursday that week. That way we don't get on top of Thanksgiving, and yet we can still have our 2 meetings. If we can get everything done in 1 week, could cancel the second one.
Is everybody okay
Did
with this?
everybody follow those dates? The 10th and the 13th is November's.
Got it.
Does that work? Does that work okay for staff?
Steve, is that good for you?
Monday night?
What she just spoke about, yeah, those are good.
Okay, good.
Thank you, Deb.
And you just let me know.
Yeah, well,
Yeah, just let us know.
Okay. All
Is there
right.
another month that you have a problem with?
I'm looking now, I have a problem with the Florida Keys Days, I'm not gonna be able to do that.
Yeah, well, we can't move, we moved the meeting, but we can't move.
Right, no,
Tuesdays.
that's, I don't have to go, that's fine. You guys can go represent. Yeah, I think I'm pretty much, oh, and then, did we do something in July?
No, we didn't. What
Yeah,
do
the
you need?
8th and the 10th are gonna be difficult to me. Would anybody be open to, say, 15th, 17th?
It's okay with me. It's okay with,
If it helps you, Steve.
when's, that's not across mini season, right? When's mini
No,
season?
that's the following.
Does that help you?
It's the following week?
Is that okay,
Okay.
the 15th and the 17th, buddy?
I don't care.
You don't care. Don? Just tell me. Okay, so we'll move July to the 15th and 17th. Marnie, is that good? Is that good for you, Steve? Anything else?
Is that okay?
Yes.
That's
We
it.
don't.
That's
did-
it?
Did we
Okay,
hit
good.
something on staff?
And we can always, we can always,
Okay.
if somebody can't be here, we can Zoom. They
Yeah.
can Zoom.
We can,
Okay.
yeah, we can figure it out.
All right, so,
So do you need a motion on this or what?
Yes, if you could do a motion to just approve the meeting calendar as amended.
okay, I'm looking for a motion to approve the calendar as we just did it.
I'll make a motion to move the calendar as just described.
I'll second.
Okay, Marnie, would you please call the roll?
Councilmember Deb Gillis.
Yes.
Councilmember Steve Friedman.
Yes.
Councilmember Buddy Pinder.
Yes.
Vice Mayor Don Horton.
Yes.
And Mayor Sharon Mahoney.
Yes.
That motion passes 5-0. Thank you.
Okay, thank you very much, and I believe we're moving on to Mr. Quick.
We are in the ordinances, which is, this is an ordinance, it's tab B, it's an ordinance on first reading. It's an ordinance of Islamorada Village of Islands, Florida, extending the temporary moratorium established pursuant to ordinance number 23-10 relating to the acceptance of new market rate residential building permit allocation system, BPAS applications with or without land dedications, providing for severability, providing for conflicts, providing for the transmittal of this ordinance to the State Department of Commerce, and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. This is, the village currently has and has had in place a moratorium on accepting any new building permit, market rate building permit applications. It does not impact those that are already in the system. It's just on the acceptance of new applications. It has been pending. It will be 1 year in February, and that's when the current moratorium will expire. It was originally enacted as a 6-month moratorium with the ability to extend it. It has been extended one time, and there was discussion requesting staff to bring it back for consideration of a second extension for the building, for the new market rate applications. I will say from the legal standpoint, there is one thing that I would like to mention. Under the Burt Harris Act, there is an exception to any, or a prohibition on any claims where an alleged taking took place for 1 year or less. So arguably, by extending this moratorium, somebody could argue that there is a taking, and we wouldn't be able to waive that exemption that's built into the statute up. So I would say there's a slight risk to somebody being able to potentially make a valid claim. There are a number of factors that go into it, but I do feel it important to at least mention to you all that that provision in the statute won't apply, because we'll be beyond the 1 year as long as there's no interruption in the moratorium.
Okay, thank you. Did you want, I was going to open public comment. Do you want to say something
No,
first?
do public comment
Okay.
first. No.
Hey, John, so how far are we moving it this time?
It's drafted for an additional 6-month extension, so it would push it from, it would extend it into August.
Okay.
And obviously, you know, the reasoning behind it, I mean, I know we had discussed it all in the past, but obviously there's a number of reasons behind a moratorium, and we're going through the comp plan process. We're working with them, and we're working with Department of Commerce in terms of are there going to be any more allocations to bring forward. So there's a number of absolutely valid reasons to support a moratorium if you all want to do it. But I did want to mention that one legal quirk that wasn't there the last 2 times.
Okay, thank you. So can we open up public comment, please?
Okay, first up is Van Cadenhead.
Van Cadenhead again. I pushed for this moratorium several times until you finally did it, because I said you were digging further into a hole if you allowed people to continue to apply. And because of the moratorium, I think that what Mr. Quick just mentioned, I don't think the people have a legal basis to give us any problems, because they don't have any paperwork that we're closing them out of. So I would continue the moratorium for 6 months. I would recommend that strongly. And the other reason, the overriding reason, is our Able Cities East is coming in here and is going to be discussing the land development regulations in workshops and the comprehensive plan in charrettes. And I think we should have that in the rearview mirror before we talk about lifting any moratoriums. So we're in a state of homeostasis at the present, and I think we should remain there for at least the next 6 months. Thank you very much.
Thank you. Marnie, anybody else?
Yes, Mr. Wishmeyer.
Yes, Joe Wishmeyer, Plantation Key. I'll make this short and simple. I support this. I believe that you all should support this until we get our new comp plan and LDRs, not only on market rate. I was hoping for everything else, so that we make sure that decisions we make now comply with whatever decisions they come up with in our new comp plan and LDRs. So I would really strongly hope that you support continuing the moratorium. Thank you.
Thank you very much. Anyone else?
No, ma'am.
Okay, public comment is now closed. Council, I see hands. Go ahead, Deb.
Go, Deb.
Okay, so I do support this. We do have a new comp plan that we're working on, and we do have potentially more allocations. I don't think we have a time frame on either one of when they would be finished. The comp plan, if I understand, is probably well over 6 months. And who knows on the allocations, depending on what path that goes on. We might get some of them, we might not. But either way, I do support at least the 6 months. It helps us get time to organize. I would ask, what is the possibility, not that I want to think of it right now, but what is the possibility of doing in August another extension?
I mean, I guess it would depend on where we are in terms of the comp plan and with the allocations or potential allocations from the state. If those are still pending, I think that we would have a good,
A fair
basis
Okay.
to do it if you all are still interested in that. And,
Okay.
and I would agree with the timeline that you talked about on a comp plan. I think at least 6 months is standard, and a lot of times it takes a little bit longer.
Thank you. So I would support this.
Okay, thanks, Deb. Don?
John, can you explain to me the difference in what we're doing here? And like, since we're going through the comp plan, the LDR process, zoning in progress?
Zoning in progress and a moratorium are slightly different. So zoning in progress basically is a shorter freeze that so you have ordinances have 2 readings. So if you pass something on first reading, between first and second reading, there's a provision in our code where zoning in progress can kick in, which means while it's pending, if it passed on first reading, you need to comply with everything, including the potential new restrictions that are coming in the ordinance. Then when the second reading comes in, if it passes, then, and once it's approved by Commerce, if they have to approve it, that becomes the law. You only have to comply with that. If it doesn't pass, then zoning in progress goes away and you just stay complying with the original terms. The moratorium is a longer freeze, and it's not necessarily tied to any one code change, but it's a broader look in terms of we're doing a slew of changes. So you wouldn't come through. It would be more difficult to do it through a zoning in progress, and the zoning in progress would be much shorter in doing so. So.
Okay.
I hope that was a little wordy.
Yeah, I got it. Okay. I got it. Yeah.
Sorry.
I'm just seeing if that was another alternative that may get us away from potential Bert Harris claims, but that's good. Okay, I get it. Thank you.
Okay. Steve, anything? No? Buddy? No, I'm good with it too. So I guess, do I hear a motion from the council?
I'll make a motion to extend another 6 months on the moratorium building permit allocation system.
And I'll second the motion.
Okay, Marnie, would you please call the roll?
Vice Mayor Don Horton,
Yes.
Councilmember Deb Gillis,
Yes.
Councilmember Steve Friedman,
Yes.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
Yes.
The motion passes 5-0.
Thank
We'll
you.
bring that back for second reading
Okay.
in the January meeting.
Thank you very much. Okay, now we're moving on to the quasi judicial, and Mr. Quick, please.
Yeah, we're in the quasi judicial section of our agenda. This starts on tab C. Please be advised that the following agenda items are quasi judicial in nature. If you wish to comment upon these, please inform the village clerk by filling out the available sign-up form. An opportunity for persons to speak on each item will be made available after the applicant and staff have made their presentation on each item. As a reminder, testimony in quasi-judicial items must be in person. Zoom testimony is not permitted. These proceedings will be handled in accordance with the village code requirements. All testimony, including public testimony and evidence, will be made under oath or affirmation. Additionally, each person who gives testimony may be subject to cross-examination. If you do not wish to be either cross-examined or sworn, your testimony shall be disregarded. The general public will not be permitted to cross-examine witnesses, but the public may request the council to ask questions of staff or witnesses on their behalf. The full agenda packet on each item is hereby entered into the record, along with the village code and comprehensive plan. Any correspondence that was received by village staff is included in the file and part of the record. Persons representing organizations must present evidence of their authority to speak for the organization. Further details of the quasi-judicial procedures in section 30-256 of the village code may be obtained from the village clerk. Tonight there are 10 quasi-judicial items, which are tabs C through K. At this time, I would like to ask anyone who intends to speak on the quasi-judicial items tonight to please raise your hand to be sworn in by the clerk if you intend to speak at all on, again, and this is tabs C through K.
In the testimony in which you are about to give, do you swear to tell the truth, the whole truth, and nothing but the truth? The witnesses have been sworn.
Madam Mayor, we're starting with tab C, which is states as follows. Tab C is a resolution of the Village Council of Islamorada Village of Islands, Florida, considering the request of Island Construction Management, Inc. for administrative relief from the Village Building Permit Allocation System for property located at 33 Flamingo Hammock Road, Upper Matacumbe, as legally described in Exhibit A, providing for transmittal to the Department of Commerce and providing for an effective date. Council, before we begin, I would like you to please disclose any ex parte communications that you may have had with the applicant or anyone else. Again, this one is just on tab C. Please include whether the person represented any group or entity, as well as the subject matter as best you recall. Thank you.
Start with you, Deb.
Sure. The only person I spoke to about this is Ty Harris, and the subject matter was just in general what this property entailed.
Okay, Don?
Out of the abundance of caution, I need to recuse myself from this item. There are several others that I will recuse myself from. If you want me to do them now, or I can do them later, it doesn't
I would
matter.
wait.
I could do them, I'll wait
Doing that.
until.
And,
Okay.
and so you won't need to disclose any ex parte because you're not part
I'm
of the
recusing
quasi-judicial
myself. Yes,
tribunal.
Steve?
I don't believe I have any.
Buddy?
I don't have any either. Only thing Ty did is, other than Ty, he just reminded me that this was coming up. So I remember it from last time, but I had no communication.
Okay, no communication for me either, okay?
All right, we are ready to proceed on tab C.
Thank you. Good evening, Council, Madam Mayor and Council. Jennifer DeBovian, Planning Director. I'm here this evening with you to discuss the administrative relief application for 33 Flamingo Hammock Road. As was stated, Island Construction Management was the applicant originally on behalf of Holly Lynn Ernst Jones Revocable Trust. In May of 2024, Ty Harris, PA, filed a new agent letter and now represents the applicant. The application doesn't change. They just get a new agent letter, so that's why the application still says Island Construction Management, Inc. I just want to make that clear. They've applied for administrative relief pursuant to Section 30-477 of the Code of Ordinances of the Village of Islamorada. Village Code Section 30-477 requires that a public hearing be held during which the Village Council of Islamorada shall consider all evidence presented regarding the application and shall follow the procedures, standards, and criteria found within Code Sections 30-552 and 30-553, otherwise known as beneficial use. The burden of proof shall also be on the applicant. The subject property is located at 33 Flamingo Hammock Road and is legally described in the proposed resolution attached. The application was entered into the Building Permit Allocation System, or BPAS, on October 24th, 2019. The application has been considered in 4 consecutive annual allocation periods and has failed to receive an allocation award. At the close of Q4 of 2023, the application was ranked 20 with 17 points. Pursuant to the requirements set forth in Code Section 30-477A, the applicant was eligible to apply for administrative relief between 12:01 p.m. on December 30th, 2023, and 12 p.m. on April 28th, 2024. The applicants submitted their application for administrative relief on January 3rd, 2024. The proposed development is a one single-family, 3-bedroom, 2-bathroom home, approximately 2,526 square feet. The site is approximately 12,192 square feet, with the allowed clearing of 50% based on habitat. The proposed development will clear approximately 4,378 square feet, with a grant of conservation easement being placed on the remainder of the property. According to the mitigation plan submitted with the permit, the mitigation fee to be paid to the village would be approximately $46,250. The analysis of the entirety of the beneficial use is in your packet. And remedies offered under Code Section 30-477F. At the conclusion of the public hearing, the village council may take any or a combination of the following actions. Grant the applicant an allocation award for all or part of the allocation requested in the next succeeding allocation period, or extended pro rata over several succeeding allocation periods. Offer to purchase the property at its fair market value. And 3, suggest any other relief as may be necessary and appropriate. Currently, the village has 23 allocations available for administrative relief. I will note that previously the council had asked us to do an appraisal of the property. That appraisal is in your packet. I believe let me just see, the valuation of the property under that appraisal was $400,000. So I don't have anything else to add at this time unless you have specific questions for me.
Anybody have a question for Jennifer, or we good to move on? Oh, go ahead.
Well, I do.
Okay.
Jennifer, they've already came once, okay?
So
and-
they were before the council in May, but at that time, though, the quasi-judicial hearing was not opened. The council directly deferred it to this evening. So there was no discussion or hearing at that time.
Okay. All right, thank you.
Deb?
Okay, my question is, if in the regular cycle, if I understand it right, the reason that they didn't gain enough points to come to the top was mostly because of the hammock on the property?
Most likely, I don't have the points in front of me, but that's most likely if they've been in for 4 years and they only had 17 points.
And you alluded to it in here, so I'm probably just repeating this to say it, I guess. That they're only allowed to clear 50% of what's on their property.
Correct.
And that's not 50% more than what's cleared, that's a total of 50%.
Correct.
Correct?
Correct.
Okay. I think that's all I have at this time.
Thank you.
Anyone else? No? We move forward with Mr. Harris?
Thank you very much. As staff stated, I represent the applicant, the Jones family, a local family, multi-generational. This is a home they've been trying to build since 2021. They've waited patiently in line. I would first, as a matter of housekeeping, like to incorporate the testimony and the evidence presented in the May hearing, since this is basically continuance of a quasi-judicial item. Probably need to put that on the record, so done that. To bring the new council members up to speed, we had quite a lengthy hearing discussing what kind of relief to give the Joneses. And there was a lot of questions and a lot of discussion about the property being in Hammock. This is a residential subdivision that's been there for a number of years, and this is just another house in that subdivision. But not to throw any council members off under the bus, but one of our dear council members on the last council had an epiphany about not allowing any kind of development in any Hammock property. It not only affected this this application, but it also killed a very nice single one-room, one-bathroom affordable housing project that was proposed by Habitat for Humanity. So that decision caused a lot of damage, in my opinion, throughout the village. So because nobody can make a decision on really whether to give an allocation or to add points to this application, we punted till this meeting. So now this council has an opportunity to pick up where the last council could not and render a decision. As Jennifer stated, the criteria, you have three choices. And the first choice is to give an allocation, which is my client's preference. The second would be to purchase it, but part of that is that you actually have to have an offer and an acceptance, and my clients aren't willing to sell this property, and certainly not for $400,000. Good luck trying to buy a lot in there for $400,000. And third, there's this provision of, well, you know, other relief. And nobody's ever quite figured out what other relief means, but it could take the form of lots of different things. We would prefer to stick to what we know, which is an allocation. They waited in line. In your discussions earlier tonight, you decided that you did not want to move forward with another a moratorium on administrative relief, that it wasn't fair. And essentially, this is what we have tonight. What's fair to this family? And I would respectfully ask that you move forward and give them the allocation that we normally give to properties in residential subdivisions. And let's put this one to bed and move forward. Thank you for your time, and I'm here to answer any questions.
Anyone have a question for Mr. Harris?
I just reserve the right to ask later, depending on how the conversation goes.
Steve, do you have anything?
No, for Ms. Harris.
Okay, thank you very much.
Thank you.
And so under our code, the next step in quasi judicial is to open it up for participants from the public in support of the application.
Okay, who do I have in support, Marnie?
I only have one person signed up for this one, and they did not indicate opposition or support, and that would be James Jones.
I'm guessing he's support. I'm guessing.
Welcome, Jim.
Hi, good evening. I'm James Jones, resident of Plantation Key at 262 Mohawk Street. I want to thank the council for their service, first of all, and congratulations on your elections. You know, we took a pledge when we got in today for liberty and for justice for all. Me and my wife have gone through the entire process. We've done everything that we were supposed to do. We have a plotted lot in a subdivision that has city water and sewer. It's been our dream to build a home there. We've waited patiently. We've paid all the fees. We've done everything we can. We have been delayed over a year now because of this, and because of this has cost us stress. This has cost us money. This has costed us a lot of time. I'm asking you guys to vote to give us the permit tonight to do the right thing. We have waited. We don't have an agenda. We love the Keys. This is our home, where we have our family here, and this is where we want to be. Our families grow, things happen. We went and did the right thing and got a lot that is a buildable lot in a subdivision. There's houses on either side of me, behind me, and going up across the street from me.
Yep.
I thank you for your time and your service, and I just please, again, ask you to award and do the right thing. Thank you.
Thank you very much.
Thank you, Jim.
Now I guess I'm looking for opposed, Marnie?
There's no one else signed up for this item.
Okay, so then I guess we move to the council now?
Yes,
Okay, council, do you have any thoughts on this?
unless the applicant wants to cross-examine himself. But I assume Mr. Harris doesn't want to cross-examine his own client.
Oh, come on, let's let him do it. Okay, Steve, do you want to
Yeah,
start?
just, Jennifer, could I get some clarification on the hammock issue?
Sure, did you have a specific question?
Just some of the history, what that's about, what happened.
I'm not sure I understand your question.
Why there's an issue building in the hammock, or there isn't an issue building in the hammock?
There isn't an issue. They're allowed to clear up to 50%, which is what they proposed.
Okay.
And then they have a mitigation plan for the rest, which I think I iterated was about $46,000 that they will pay to the village.
Okay. All right, thank you.
Yeah. Jennifer, that is a plotted subdivision too, right?
That is a platted subdivision, yes.
just jumped right in.
It's
Just to be clear, is that the one that's basically
Behind Publix.
behind the Publix.
behind the Publix, right?
Yeah.
Okay, thanks.
Don?
It's just another example of what we just got rid of, the moratorium. This is the example. These folks have been in here for more than 4 years, and I just think that, like so many other in the past, they need to get approval, but that's up to y'all. I'm out of this one.
Deb?
Well, I'm ready to make a motion to give them an allocation if the council is ready to hear that.
The only thing I want to say is I was on the last council, and I did not agree with other council members. I believe this family has played the game that we created. They've done everything, and they deserve what all of us want, is a home here. So if anybody has anything else to say?
I just want to back you up, Sharon, and say Holly grew up here. Her daddy grew up here. Her grandmother grew up here, okay? We're talking about, and their daughter lives here. I mean, this is what I'm talking about generational, okay? That want to live here, okay? And they followed the system, and I know there was somebody on council before. I didn't agree with it either, and I think we should give them their permit tonight. They've waited very, very long. It's cost of construction have gone up. It's in a plotted subdivision, so
Okay.
anyway.
This one is also what I would refer to as an infill. I mean, it's not out in the center of.
Exactly.
It's a what? I didn't hear it.
I call it an infill, meaning that there's houses all around it. It's a vacant lot inside.
Right.
So do I have a
development
motion?
already.
Are we talking about a market rate?
Yes.
Yes.
From the
Administrative
administrative.
to upgrade to market rate?
Well, it is a market rate, but it's inside the administrative relief
Okay,
pool.
gotcha.
It's been
And
almost
I'll-
5 years, Steve.
Yeah, I just want to make sure that we're doing things the right way, despite the fact that people may have grown up here, we're friends with them and all that, we still have to do things by the book.
They did. They followed. They've been in 4 years, and then they had to pay $1,500, and then they applied for administrative relief, and then they came for administrative relief, but we didn't even give them
But
a
it got
chance.
tabled.
And anyways,
Okay. So again, do I have a motion?
I'm making a motion to approve an allocation out of the administrative relief fund. Is that how that should be?
and I will second that motion.
Yeah, or you
Is
can
that
say
right?
a motion to approve, yeah, exactly. That's-
Okay.
And we have a second with Mr.
And
Pender?
just one thing before we vote, there is the ability for a final argument from the applicant. But I just want to make sure we offered it to them.
Okay, so Marnie, would you please call the roll?
Councilmember Deb Gillis.
Yes.
Councilmember Steve Friedman.
Yes.
Councilmember Buddy Pinder.
Yes.
And Mayor Sharon Mahoney.
Yes.
The motion passes 4-0.
Congratulations.
Finally.
Okay, moving on to the next section, and that would be me. And I'm told I have to recuse myself, and I get to give Don but you can't keep it, okay? You can't keep it.
I don't
You
need
better
it.
make him
I don't
promise.
need it.
You
Thank you.
get this
Okay.
for 2 items that we're going to probably combine
The
into
next two,
one.
so I'm stepping back, so go ahead, please, Mr. Quick.
All right, the next 2 items are, well, let me just ask this. So there's tab D and E, so one is a future land use map change, one is a zoning map change. They're companion items. You can't have one without the other. Usually what we do in this situation is that we combine them both for the same hearing, although we will vote on them separately. I just want to make sure that council is okay with that, as well as the applicant is okay with that. Is that okay that we combine them?
Yes, sir.
So to further explain, it's a FLUM change, future land use map change, and a zoning change. And the arguments behind them are pretty much the same. It would be redundant to hear them twice, so we'll hear them both together unless there's any opposition to that. Okay, let's do that.
And
Yeah.
I was going to add on to that explanation
You can
because we have some, thank you.
Yep.
That it's very difficult to separate the conversations from one to the other. You end up cross-talking
They
about them
overlap
all
each
the
other.
time.
Right, yep.
So
Okay.
if we put it at one but vote separately, we can get this done.
Yep, exactly. So I'll read both titles now. Tab D is an ordinance of Islamorada Village of Islands, Florida, considering the request of Sharon Mahoney on behalf of HVS 82 Investments LLC to amend the village's future land use map from residential conservation to mixed use for the subject property located on Plantation Key with real estate number 004158440-000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. I didn't say this is an ordinance on second reading. Tab E, also an ordinance on second reading, is an ordinance of Islamorada Village of Islands, Florida, considering the request of Sharon Mahoney on behalf of HVS 82 Investments LLC to amend the official zoning map from native residential to highway commercial for the subject property located on Plantation Key with real estate number 004158440-000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. Before we begin, Council, if you would please disclose any ex parte communications you've had with anyone. Again, this is on both tabs D and E. And please include whether the person represented a group or entity as well as the subject matter as you best recall. Thank you.
I'll go first. I had no communication whatsoever, not even with Jennifer.
I didn't even know there was a structure back in there.
Yeah.
Well, I had a little bit of conversation with Sharon about the property, but I, just on the sake of whatever, I sat on LPA and heard these items as an LPA member.
So you heard it before you were elected?
Well, yes.
Okay, thank you.
Yes, and that was all public hearing too.
That was public
Yes.
hearing,
Right.
yeah.
I've had no conversation. All right.
We
the
are ready to
applic-
proceed.
Does the applicant like to present?
Usually
Staff,
staff
yeah,
goes
staff
first.
first.
Staff present, I'm sorry, I'm sorry.
okay.
Staff. Go for it, Jen.
She's got the
I don't have
cheese.
much to say. These are two ordinances for second reading. The previous council had approved these under first reading. The applicant, HVS 82 Investments LLC, has submitted both these amendments. The future land use amendment is proposed from residential conservation to mixed use, and the zoning amendment is to propose change from native residential to highway commercial. The subject property is located at 88755 Old Highway. It's comprised of 12,000 square feet. The property is developed with an existing commercial greenhouse. Under first reading, the council had several conditions that are in your packet. We rendered the FLUM amendment as required to the state for a coordinated review. On June 14th, we received a report back from Florida Commerce not identifying any objection or comments from the state coordinated review. And then, however, between first and second reading, the applicant has requested that a change to one of the conditions. She's asked that the condition number 2 regarding the grant of conservation easement be removed. I've provided you with 2 resolutions, one with the condition and one without, so that the council may review both and decide which they prefer. I don't have anything additional to add. If you want me to go through the entire packet again, I'm happy to do that, but because it was second reading, I don't typically do that, so.
Okay. Does the applicant have anything to present?
Should I say something?
If you want to explain why you want the condition removed, maybe?
My father acquired this property in 1960. It was zoned BU2, which was commercial. In 1990, I paid $10 to my dad and owned the property to go along with my flower shop. I built a commercial greenhouse. It is commercial. All my permits were commercial. I have handicap parking, handicap bathroom, and I found out 7.5 years ago that the village rezoned me residential, and I've been 7 years trying to correct this. It is a greenhouse, a cement structure that my dad designed. It will take hurricane force winds. What I want to do is put a roof on it and brick up the sides and turn it into a nice office building for a dentist, an architect. Do not want to change the size of anything, do not want to clear anything. I just want my zoning back to what it was. And if you have any questions, I'd be glad to answer them.
Thank you.
Now we would open it up to anybody.
Any public comment?
Yeah.
So is there anybody against? Is that what you want to do?
The first one is,
For?
that is in support.
Okay, is there anyone in support that would like to speak?
Okay, first up, we have, well, we can take Van first, and then Mr. Wishmeyer.
Ho, 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 and Merry Christmas. I've seen this property since 1960, and everything that Madam Mayor said was correct. And this is, in my opinion, a remedial action that we're doing for her to correct something that was done by the first council. So I would urge you to grant her what she's asking for in both of these instances, because I think that would make something that was wrong back to being right. Thank you very much.
Thank you, Van.
Yes, Joe Wishmeyer, Plantation Key. I'm pretty much was going to say the same thing that Van did. I mean, it just doesn't seem right what they did back then, and I'm glad that you're taking the opportunity to correct it. The only question I had was about the restrictions that were on the first reading, and I didn't know if it had to be changed from the first to the second or what, but I'm in full support of this.
Thank you, Joe. Is that it, Marnie? Is there anyone for or against, I mean? Ty, are you in?
I put up a card for 4.
Yes, Ty did put a card in for 4.
Again, Ty Harris, Plantation Key. It's not often that Van and Joe and I all agree on something, but I love it when it happens, you know. Again, this is about righting a wrong. I call it, and I've said it before, it's the original sin of the village from a planning perspective. You do not take properties and turn them into non-conforming uses. And that's what happened in this case. It's happened all the way down to Lower Matacumbe. And over the years, people have realized that that's happened, and they all want their zoning back. And you can't blame them, because this property was commercial. It was developed under a commercial county code. There's no need for a conservation easement on it, because it's already cleared to the max. It cannot be cleared anymore. So why are we going to belt and suspender something when we don't have to? That's just extra government when not extra government is needed. So in keeping with my brothers Joe and Van, I would urge that you approve this. Thank you.
Thank you, Ty.
It must be Christmas.
Marnie, anyone else?
There is no one else to speak.
Even against?
Correct.
Get lucky sometimes, huh? Yeah. Okay. All right, is there any discussion on up at the Diaz with council?
I don't have any discussion.
I have just a little bit. On this conservation easement, I was involved because I was on LPA, and I heard it before, that I know that on the restrictive covenants that there was a map missing, but we were able to determine what that was, and I actually voted in support of this, and I still am voting in support of it. But with the conservation easement, help clarify that, since we have a missing map.
I can address
Sure.
that. So we have corrected the restrictive covenant. The map has been discovered. Sharon dug through her old box of plans and papers, and we discovered the Exhibit A. Rice Rhoda helped us draft a corrected restrictive covenant. We re-recorded it. It's been recorded, so that's all been corrected.
Oh, I didn't know that. I'm sorry. In that case, I don't have any
That was
other
actually
comment.
the first condition that the previous council had put on the approval, so.
Anyone else? No? I gotta tell you that I wanted to do my research on this, and I don't care how many pages there are, I did my research. I pulled my own zoning map, and it is BU2, and it's amazing because it stops right at that lot. Going north, it goes back to BU1, and I pulled the old county code. And it's amazing what was allowed in BU2, and I forgot that they allowed for stacking, and they allowed for, pages and pages of uses that included saloons and multifamily structures and storage buildings and warehouses and cold storage and even brew houses. It was pretty cool. Munitions deposits from the 60s they would allow. So I think this is a perfect example of righting a wrong. The county, it had the right zoning, the county zoned it down further, and then the village went in here and just devastated this property with a residential conservation. And I just think it was a wrong thing, and it's an example of why we need to get this code updated and why we need to pay attention to what our planning directors do as we go through there, because we allowed the planning director to make this a non-conforming piece of property, and there's a lot of them all over this town.
I want to speak, Don, before
And I've
you-
changed it. Okay, go on, buddy.
Okay.
No, please.
I just, Joanne and Sharon both called me years ago before I ever got elected and asked if I would help them. I went straight to the county and got it all. I mean, I got a whole packet from them that I gave to Sharon. And then I also got the village packet where Mr. Joe Michaelis, he'd since sold his property, but he changed his too. So the property that adjoins her property, but yeah, the county's got a lot of good info there. Anyways, that's all I have to say.
All right. Thank you. Do I hear a motion then?
Yeah, we'll do them one at a
We'll do
time,
one at a time.
and with tab D, and I'm assuming, do you want to, closing argument? With tab D, just whoever's making the motion, just to remember to include in the motion whether if it's an approval, whether it includes the condition for a conservation easement or not.
Okay, I'll make a motion that we approve this and with no conservation on both items. Is that good, John? What do you need?
Yeah, that'll be fine. I mean, it's only on tab D that
Okay.
has that requirement.
We'll let you do it
in
again.
So
Okay.
So it'd be a motion to approve tab D without the requirement for a
Okay, so I make a
conservation
motion
easement.
to approve tab D without the conservation restriction.
And I'll second that motion.
All right, we got a motion and a second. Marnie, will you call the roll?
Councilmember Buddy Pinder?
Yes.
Councilmember Deb Gillis?
Yes.
Councilmember Steve Friedman?
Yes.
And Vice Mayor Don Horton?
Yes.
That motion passes 4-0.
Okay, now I need a motion for the next tab.
I'll make a motion on the next tab to, as recommended, to change the zoning
That's
from, do I need to say from and to?
Tab E, right?
Tab E,
It's
yes.
Tad E. Did I say something different? I'm sorry.
Yeah, you can just
Tad
say
E.
a motion to approve the proposed ordinance at tab E.
Okay. I make a motion to approve the motion as presented on tab E.
Do I have a second?
Yep, got a second.
All right. Marnie, will you call the roll?
Councilmember Deb Gillis?
Yes.
Councilmember Buddy Pinder?
Yes.
Councilmember Steve Friedman?
Yes.
And Vice Mayor Don Horton?
Yes.
That motion passes 4-0.
Hallelujah.
Take it
7.5 years. Thank you. Thank you so very much.
There is right in this happens.
I
in
hope
this
so.
world.
Thank you. Okay. Do we want to continue on, or does anybody need a break? Are we good?
Let's do
Move
it.
on.
Jennifer's got a
Okay.
plane to catch.
Oh, well, let's get Jennifer. Okay, so that we are on, Mr. Quick?
Yep,
E?
we're on tabs F and G.
Okay.
We'll speak. Do you want, okay. Ms.
What happened
Tiedemann, do you
to-
have any issue with taking all four of your items together, F, G, H, and I? Okay, I will read all four of them, and we can take them together for one hearing, but we will vote on all four of them individually. Tab F is an ordinance of Islamorada Village of Islands, Florida, concerning the request of Winley Cove LLC to amend the village's future land use map from residential medium to mixed use for the subject property located on Winley Key with real estate number 00405-350-00000, as legally described herein, and to allow the parcel to be included in policy 1-2.11.4, Winley Key Mixed Use Area 2, providing for the transmittal of this ordinance to the State Department of Commerce, and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. And I forgot to mention, this is an ordinance on first reading. Tab G is also an ordinance on first reading. It's an ordinance of Islamorada Village of Islands, Florida, concerning the request of Winley Cove LLC to amend the official zoning map from residential single-family to highway commercial for the subject property located on Winley Key with real estate number 00405-350-00000, as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce, providing for an effective date upon the approval of this ordinance by the State Department of Commerce. Tab H An ordinance of Islamorada Village of Islands, Florida, concerning the request of Winley Isles LLC to amend the village's future land use map from residential medium to mixed use for the subject property located on Winley Key with real estate number 0040536000000 as legally described herein, and to allow the parcel to be included in policy 1-2.11.4 Winley Key Mixed Use Area 2, providing for the transmittal of this ordinance to the State Department of Commerce, and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. Tab I is ordinance on first reading. It's an ordinance of Islamorada Village of Islands, Florida, concerning the request of Winley Isles LLC to amend the official zoning map from residential single-family to highway commercial for the subject property located on Winley Key with real estate number 0040536000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce, and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. And Council, before we begin, I would like you to please disclose any ex parte communications that you may have had with anyone with regard to tabs F through I, and please include whether the person represented any group or entity as well as the subject matter as you best recall. Thank you.
Deb, start with you.
So I spoke to Jocelyn on the first go-around and when it was at LPA, and it was just concerning what the property was about and like. And I also need to disclose that I think that I was on LPA when it came forward there, but that was a public hearing also.
Okay. Don?
Out of the abundance of caution, I'm going to recuse myself on F, G, H, and I.
Okay. Steve?
No, nothing to review.
Mr. Pender?
Nope. No communication.
And nothing for myself either, so,
All right, we're ready to begin.
okay.
Thank you, Council. Jennifer DeBoer, and again, Planning Director. Here this evening for Winley Cove LLC and Winley Isles LLC. The applicant has submitted map amendments for the FLUM and zoning for both properties. One is located at 85327 Overseas Highway, and the other one is located at 85331 Overseas Highway. The applicant is requesting an approval for a future land use map from residential medium to mixed use designation for the subject properties, and a zoning map change from residential single family R1 to a highway commercial district. The FLUM amendment cannot be approved without the companion zoning amendment, and the applicant has submitted a letter detailing the map amendment request. It should be in your packet. The applicant owner intends to pursue acquiring vacation rental license for both properties, and the reason for the change is we do not allow vacation rentals in residential medium FLUMs, and so that's why she is requesting this change. In order to solidify her request, she has also suggested or proposing that the properties be placed in the Winley Key Mixed Use Area 2, which will restrict the development of the properties to single-family homes only. And that would still allow her to do the vacation rentals, but it would not allow any other development, commercial development. It would only allow the single-family home to stay there. So that's the proposal before you tonight. These are the two homes that are located immediately adjacent to the Hog Heaven, if you're not familiar with them. The properties currently have an existing residential medium future land use. The surrounding properties to the south are also designated residential medium. The properties to the north are mixed use. The properties to the west across Overseas Highway are conservation, and to the east is the Atlantic Ocean. The character of the subject properties are single-family homes with some mangrove wetlands to the east of the property, and the surrounding area is mixed use with a collection of restaurants, marina uses, single-family residences, and conservation land. The subject properties have single-family residential, single-family R1 zoning designations. The surrounding properties to the south are also designated residential single-family. To the north, the adjacent properties are designated highway commercial. The properties to the west across Overseas Highway are designated conservation. To the east, again, is the Atlantic Ocean. And the character of the subject property is single-family home, again, with surrounding area with collective of restaurants, marina uses, single-family residences, and conservation land. In your packet is the analysis. This was before the council previously, and the applicant had asked for a deferral, so that's why we're here this evening. Again, the proposed FLUM amendment would not alter the development potential of the subject property the development potential of the subject property by allowing one additional market rate unit and 5 affordable housing units. The new FLUM would also allow for hotel motel density. However, adding the property to the Winley Key Mixed Use Area 2 would not alter the development potential because it would restrict, again, the property to a single-family home. At this time, based on the, let me back up. When this property was before the council previously, there was a lot of concern about the parking in the Winley Key area, which we discussed at the beginning of the meeting, and vacation rental compliance. The parking in the Winley Key area has been addressed because the village took it upon itself to request that those vehicles be moved so the Florida Keys Aqueduct Authority could use that for their staging. So that has been addressed. In your packet, I had compiled a vacation rental compliance monitoring checklist. I had gone through our regulations and our code regarding vacation rentals and I had talked with our fire inspector who does our vacation rental inspections. And I had put together this checklist and how we would propose to verify and enforce those things. So I have this checklist in here and we could monitor those vacation rentals. Hopefully that would help address some of the concerns regarding vacation rentals if that's what the council is still concerned about. So based on all of that and the fact that these properties will be placed in the Winley Key Mixed Use Area 2, at this time staff recommends the adoption of both these ordinances. And I don't have anything else to add, but I'm here to answer any questions.
Anyone have any questions for Jennifer? No? So Marnie, we start with the applicant? You ready?
Yeah.
Go ahead.
Ready as I'm going to be. All right. Well, good evening, council. Congratulations on your election. Okay. So, for those who have not heard my presentation, I'll go over it again simply. I bought these properties, approximately 3 years ago. I wanted to develop two, beautiful homes to accent the community. Come from a, legacy of my father being a builder, and I take a lot of pride in my work, and I, of course, build my homes to top quality, and I just really wanted them to come out beautiful. And when you drive by, people admire them, and I was very happy with the way they came out. As we, of course, started this project, we did start getting input from, just contractor friends, real estate agents, as it was my intention to build these and sell them. Just of best way to, what would be the best use out of the homes. And we did get a lot of comments that people thought they were a great location to have the ability to do vacation rentals. So I started the project to go forward and, apply for the application almost a year ago. We've been working on this. So the homes now have a CO. They're completely done. So with them being finished, of course, with underneath the sub policy too, you will not be able to add any type of additional uses to it other than exactly what's there for a single family use. So I think it's very important to understand, it's not a standard zoning change. You're underneath the sub policy. So for all those other uses that are typically allowed in highway commercial, you're not allowed to do, like you said, the motel or upselling or getting a higher density out of it. It still is with this requested zoning change use, the exact same use of what the property is going to be right now. It's going to be for, the same occupancy of what's allowed in it, and it's not going to be changing the use to what it already is. It still will be remaining 100% residential, so that does not change. And I think it's very important to acknowledge that and understand it. The one and only change that can happen through this zoning change is the ability of the difference of duration of someone can stay in the property, which right now is a minimum of 28 days, so we'll be going to 7 days. That is the sole difference in accomplishing this zoning change. I had Jennifer pull up a map of all of Winley Key to just show you what Winley Key is. Winley Key is, a high, the whole key is either highway commercial or tourist commercial. There is actually there shows 7 parcels there, but one of them is actually incorrect. The one closest right here, that one is actually already changed to highway commercial in a previous zoning change that was approved by the village staff. So there is actually only 6 R1 sites on all of Winley Key. And in those 6 sites, I own 3 of them. The property, even to the south side of my property, that is where I plan on building my own future personal residence. So my property will actually serve as a buffer to the next residential property beside me. These properties, back in 1997, before the village was incorporated, these were all suburban commercially zoned. So they were not zoned before, when the village was incorporated in 1997, and then 2001, they were changed to R1. So we again are just going back to the original zoning of the properties to what they were. And as I mentioned too, the one property closest to Hog Heaven, that one was the exact same situation. There was a single-family home there. They actually tore down the home, and they made that into a highway commercial lot, which they use as an accessory structure to their restaurant. So there already is precedence from having a previous zoning change at the exact same similar circumstances. And they have a sub-policy, and my sub-policy is actually even more restrictive than theirs, only allowing the use of vacation rentals and still keeping it as a single-family residential home. I know there's been concern about parking. Even at Angler's Reef, when you're talking about parking, they have 2 units, only 2 parking spots per residence. I have an abundance of parking in my property. It's all enclosed by a privacy wall. It actually can easily occupy 5 to 6 cars underneath the carport and in the driveway. So parking is not an issue. We're not going to be having overflow out onto the road. And by even the wonderful vacation rental compliance monitoring checklist that Jennifer supplied, it very clearly states it's 2 occupants per room. So whether it's a 7-day rental or a 28-day rental, it's the same amount of occupants still staying in the home. So that does not change. So just in essence, you're not creating a density change. You're not creating an intensity change. It is still the same style home. There is no commercial use. There is no other businesses other than vacation rental allowance, and there is no upzoning with the same use of the property. It just makes sense, out of the 331 vacation rental licenses that are in Islamorada and still being a surplus of vacation rental licenses, it just makes a lot more sense to steer these open licenses to an area that has the least impacted, density of residential and put it into a high density commercial area. I think that's about it. There are quite a few vacation rentals there in Angler's Reef. There's 19 of them. That's only about 500 feet away from the property currently right now. The village staff approval has recommended for approval. The LPA voted on it 6-1 for their approval. And I'm hoping that you guys understand that it's just a great spot to steer these open vacation rentals and see that it's not going to impact the community in a negative way. And in essence, I think actually, help the community and bring somewhere for tourists to come in an area that's not going to be affected and bothering neighbors. So I think
Does
that's
anybody
about
have
it.
any questions before? Okay, so I guess we now open who are in support of this first, Marnie?
I don't have anyone specifically signed up in support, but I will start with Elizabeth Jolin to speak, as she doesn't have support or oppose on it, and then everyone else is opposing.
Marnie, I'm sorry, I misidentified the tab. I wanted to speak on J.
Okay, all right, thank you.
Okay.
All right, well, we'll start with Van Cadenhead. We don't have anyone in support, so this
Okay,
is
thank
opposing.
you.
My name is Van Cadenhead, and there's a few things I'd like you to consider before you make this decision. Mrs. Gillis mentioned that she was on the LPA when this was discussed, and so was I. And it was originally brought up as affordable housing by Mark Gregg, who at the time owned the property. And he stipulated that it was fronting on US 1. It was highway commercial. And I brought out at the time that it was not on US 1. It was not highway commercial. It was on a village road that had been given to us by the county, not US 1, which is a federal highway. So I said it shouldn't be eligible for affordable housing. So he got it to residential medium. So, and also got me removed from the LPA. And so the location is, those houses are gorgeous. They are beautiful houses. They're well done, and they should be, in my opinion, what they were. You started out with the horse across the river, and now you're changing horses in the middle of the river. And the reason that you're changing horses is to upgrade the value of the property from a single-family home, which is the precept that was built under, and the permits were granted under that idea. And now you want to change that to a vacation rental, and you can go from 28 days to 7 days, and that's what Mrs. Tiedemann brought up. But I would also point out that with the strength of a waiver, what happened at the islands of Islamorada was supposed to be vacation rentals of 28 days, and then it became 7 days. And because we got a waiver from the planning department, now it's overnight. So in essence, you have created another one-night hotel. So this is a possibility in the future for this mixed use if you grant them this change in the middle of the stream, which will enhance the value of their property greatly because it will be valued as a vacation rental instead of a single-family home, which was the precept it was accepted at to begin with. So I would say that if you grant it as a vacation rental, the stipulation should be that it could never go waiver or not, or who's sitting on the council or who's sitting in the planning director's seat should never ever be changed from vacation rental to a one-night rental, which is what we're looking at the islands of Islamorada right now with 22 units that were, they changed the horse in the middle of that particular stream too. And I just don't want to see it happen again. Thank you very much.
Thank you. Next, Marnie.
Next is Joe Ishmeyer.
Yes, Joe Wishmeyer, Plantation Key. As a victim of vacation rentals done illegally next to me, and knowing people who are next to them, even though they say they're single family, these are beautiful houses, but we're not talking about a two-bedroom house. We're talking many, many bedrooms. And these people that come down pay no attention to those of us that have to get up early in the morning and go to work. They party all night long. Oh, they sleep during the day while we're at work, and then they party all night long again. We all know the complaints we've had of vacation rentals in the past. Councils have said they are going to address this issue. As of yet, we haven't really seen anything to address it. We need to protect our residential neighborhoods. Another, for instance, is I live in a residential neighborhood, and all of a sudden, I got a 7-Eleven and a distillery bar put within 500 feet of my house. And I live in a residential neighborhood, and they told me, they said, well, when you bought, it was commercial. Yeah, it was a bank. That's a little different. And there was, so taking advantage of the residents, we have to protect the families and the residents from vacation rentals. There's plenty of other places to put them other than in residential neighborhoods. So I hope you would respect our mission and our quality of life. Thank you very much.
Marnie, anyone else?
Yes, next up is Sue Miller. There's no one else.
Okay, so I guess now we move to the council for discussion?
Yes.
Okay. Who would like to start?
I mean, I like this idea. I think in just overall perspective, we're looking at two homes that really, in terms of any kind of vacation rental impact that some of the public speakers were referring to, we have an apartment building that's kind of close by that is also adjacent to a restaurant with a lot of great smelling smoke, you know, coming from, I mean, the cooker, right? And just to clarify. So I don't think that they'd necessarily be bothered by this change, is what I'm saying, the people in the apartments. I think it'd be beneficial for the owners, and I think it aligns with basically the rest of the area there, so I'm in favor.
Buddy?
I don't have anything.
Deb? Mike?
Sorry.
Okay.
I'll make a couple comments. These two houses were actually built with market rate. The affordable that was referred to was never pulled. This Winley Key the zoning that the subzoning that we're doing, number 2, wouldn't allow any kind of motel. That's the idea of putting that subzoning in place. So I think this is a great location for this. And it's really not a residential neighborhood in that area. So I am for this. I actually voted for it on the LPA. I thought it was a good to put the subzoning in.
Well, I happen to be friends with the people who live on the other side, and they do have a problem with it. There are people who live on the south side, more than one, and they have come to me multiple times, very concerned, and I have a really hard time agreeing to this because there are people who have their homes next door. Sorry, but I do not believe it's going to be 2 people in each bedroom. I'm sorry. When this came in front of me before and Mark tried to sell that, oh no, oh come on. Who do you think is going to rent that house? It's going to be kids. And it's going to be horrible for the people who live there. So I do have an issue. They're beautiful homes. I just have a problem with the vacation rentals just because I think it's not fair to people who have lived there for several years to now have this burden next door to them. And it is a burden. Just, I mean, come on, they're here to party. Let's just be honest. Vacation rentals. And that type of house is beautiful, but you're next door to hog heaven. Who do you think's going to want that house? College kids. And, whether it's expensive or not, they'll spend the money. So I do have a problem with it. So I don't know. Where do we go from here? I guess.
We make a motion?
Someone want to make a motion?
Just the
Yeah, oh,
applicant
sorry.
has the opportunity
Sorry.
for a
Got it.
Sorry.
Yeah.
final
Me
argument.
too. Okay.
I just want to mention, thank you for your comments. Just speaking about illegal rentals, yes, illegal rentals are a major problem, and that's why I'm trying to follow the steps to do this illegally and have every process done where when someone wants to buy one of these homes, obviously they have to go through the vacation license application and comply with all the rules of acquiring a vacation rental license. It is a 4-bedroom home, so yes, it can have an 8-person occupancy, but that really makes no difference if someone has, 4 kids or living in the house. It's the same amount of occupants in the house. And out of these 6 remaining R1 lots, I would like to point out there is no homestead exemption on any of these lots. They're either transient properties or they're second home properties. So all Winley Key, no homestead exemptions on any R1 lots. So I think that is important to point out. And even people who are going to be renting these homes, I've had a nice handful of people come through and look at them. People love the homes. The comments on them, they're beautiful, they're luxury, they're built with all high-end products. I mean, there's no cheap Lowe's or Home Depot products in this house. Everything is custom. It is going to be rented out to high-end clients who are going to be coming down here doing the fishing adventures and boating. It is not going to be rented out to partiers. It's going to be at a high dollar rental value for these homes. And I think that I just believe that, it's going to be benefiting the community, and I don't think it's going to be an inconvenience in that spot whatsoever. So that's pretty much it, and I look forward and respect any of your votes. Thank you very much.
May I add one more thing?
Sure.
I listened to the council meeting where this was brought up before, and a lot of conversation went on about the vacation rentals and bringing them into compliance, and we've had the discussion lots of times over that. I actually wanted to thank Jennifer and her staff for putting together this checklist. I think it's well needed, and I think it'll help code enforcement and the officers in getting the job done in what we're doing. The illegal vacation rentals are still very difficult to find and enforce, but they're working on them. They're moving that forward. They're just hard to find. And if you know of some next door, you should report them so they can research them and make them come into compliance. Okay. All right.
Buddy?
Okay. Hey, Jennifer, is there something in there that they can't change, what Van just talked about, to one-night rentals, that once this is done, they can't come back, you know? I mean, if Jocelyn wants to speak about it, you know.
So, yeah, so the village, so that would be a transient unit, and the village has a cap on transient units. It would not be allowed to, we're not allowed to create any new transient units.
So it's 7 nights would be
Is the minimum.
okay. Okay, all right.
Okay, council, anything else, or do I have a motion?
I'll make a motion to approve tab F related to Winley Cove for the future land use map change as presented. Is that good?
Do I have a second?
I'll second.
Okay, Marnie, will you call the roll, please?
Councilmember Deb Gillis,
Yes.
Councilmember Steve Friedman,
Yes.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
Yes.
Okay, that motion passes 4-0.
We need a motion on tab G.
Okay.
I'll make a motion on tab G to approve the zoning map change on Winley Cove project.
I'll second.
Marnie, roll, please.
Councilmember Deb Gillis,
Yes.
Councilmember Steve Friedman,
Yes.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
Yes.
The motion passes 4-0.
And next is tab H.
I'll make a motion on, unless you want to do it? Somebody else want to take the lead here? Okay, I'll make a motion on tab H to approve the Winley Isles future land use map change as presented.
Second.
Marnie?
Councilmember Deb Gillis,
Yes.
Councilmember Steve Friedman,
Yes.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
Yes.
Motion passes 4-0.
And last but not least, tab I.
I'll make a motion on tab I to approve the zoning map change on Winley Isles as presented.
Second.
Marnie?
Councilmember Deb Gillis,
Yes.
Councilmember Steve Friedman,
Yes.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
Yes.
That motion passes 4-0.
Okay,
Thank you.
ready to
we've got-
move on?
Yep, we've got 3 more tabs. They are all related to the same applicant, and I believe we're going to be taking these all together, correct? Yep. So I will read them all, and then we can take them all in the same discussion, but vote on them separately.
I know.
First is tab J. These are all ordinances on first reading. It's an ordinance of Islamorada Village of Islands, Florida, considering the request of LAH Creekside LLC to, to expend the official zoning map from Village Center to Neighborhood Commercial for the subject property located on Plantation Key with real estate number 00437590-000000 and 00437610-000000 and 00437640-000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. Tab K is a resolution of the Village Council of Islamorada Village of Islands, Florida, concerning the request of LAH Islander LLC for an amendment to the major conditional use approval for the expansion of the existing hotel for property located at 82100 and 81998 Overseas Highway and 132 Carroll Street on Upper Matecumbe Key with the tourist, commercial, and settlers residential zoning districts with the real estate number 004000810-000000 and 004004500-000000 as legally described herein, providing for the transmittal of this resolution to the Florida Department of Commerce and providing for an effective date. And tab L is a resolution of the Village Council of Islamorada, Village of Islands, Florida, considering the request of LAH Islander LLC for a transfer of development rights of 5 or more hotel/motel units from the property located at 90611, 90655, 90691, and 90701 Old Highway in Tavernier with real estate number 00437-590-0000000, 00437-610-0000000, 00437-630-0000000, and 00437-640-0000000. As legally described, I didn't know I was going to say this many zeros in this short of a time ever in my life. As legally described herein, to property located at 82100 and 81998 Overseas Highway and 132 Carroll Street on Upper Matacumbe Key with real estate numbers, and bear with me here, 00400-810-0000000 and 00400-450-00000, as legally described herein, providing for the transmittal of this resolution to the Florida Department of Commerce and providing for an effective date. Council, before we begin, we would like you to please disclose any ex parte communications that you may have had with anyone and these are tabs J, K, and L. And please include whether the person represented any group or entity, as well as the subject matter as the best you recall. Thank you.
Deb, would you like to start?
Sure. The only thing I had is I sat on LPA when we heard J, which was the map amendment,
Okay.
which was a public hearing.
Are you going to recuse yourself again, or we?
No, I'm good on this.
Yay.
Okay, just checking.
I'm
So
good
no,
on this when I spoke to Bart Smith. And by the way, the property appraiser just says no split out when you have 6 zeros in a row. Because there's no split out, so the property's not split. So it might be an easier way to say, but I spoke to Bart.
okay, Steve, anything? Mr. Pender in the back of the room.
Mr. Penner.
Did you talk to anybody about this, or are you just talking back there?
No. I did. Bart called to remind me it was on the agenda, but that's all, he's the only person I talked to.
You need to be on mic.
All right, I'm getting some coffee.
Okay, I didn't speak to anyone. 0. Okay, Jennifer?
Thank you. Again, Jennifer DeBoer, Planning Director. We're here this evening for the 3 tabs before you this evening regarding the Creekside Motel or Inn, Creekside Inn, and the Islander. So this project is to take the existing hotel motel units at the Creekside, transfer them to the Islander for redevelopment, and then convert the hotel at the Creekside to workforce affordable housing for the employees at the Islander. So the first tab under J is the zoning amendment. The reason that the applicant is requesting this is because the current zoning doesn't allow for the conversion of a hotel motel to affordable units. It allows for the affordable units, just not the conversion of the hotel motel. So in order to accomplish that, they needed to go from village center to neighborhood commercial, which does allow for the conversion of a hotel motel. The applicant submitted their letter of intent detailing this amendment request. They are looking again to transfer those hotel units and then convert to workforce affordable housing. That analysis is in the packet. The second tab is a amendment to a major conditional use for the Islander Resort. This amendment to that major conditional use will take the 50 hotel units that are being transferred from the Creekside Inn and move those to the Islander and be redeveloped there. There is a full site plan that has been reviewed by all your professional staff. And conditions have been placed upon that for your review and approval. We have received no letters of objection from adjacent property owners.
Oh, your mic went off.
Sorry. We have received no letters of objection as of this council communication. The major conditional use meets all of the requirements of the site plan approval and We also had done, the reason it has taken so long to get, one of the reasons it has taken so long to get back before the council is the traffic study that had to be done, and then after it was reviewed by a third-party engineer, they needed some additional information, and the applicant provided that, and then was re-reviewed, and then our third-party traffic engineer has since been satisfied, so we have done that as well. And then the final tab in there is the transfer of development rights from the Creekside Inn to the Islander Resort. Again, that's transferring those 50 units to the Islander Resort. The two sites are compatible. They're both disturbed sites. They're both shoreline sites, and they meet all of the criteria for transfer of development. I'm not going to do what I usually do and just read the entire thing because it would be reading. So it's all in your packet. If you have specific questions, I'm happy to answer them. I know Bart has a PowerPoint presentation, so I'm sure I'll get more information there, but I'm happy to answer whatever questions you might have.
Anyone have anything for Ms. Jennifer?
Not at the moment.
Mr. Bart, you ready?
Yes,
Go ahead.
thank you for having me this evening. Congratulations, everyone, on their election, and happy holidays as well. I can feel the cold in the room from the time of year. This time I'm wearing a suit because I'm actually cold. So yes, as discussed, this is the first reading of the proposals for the additional development at the Islander, transferring the transient units there, and then redeveloping Creekside as affordable housing. And as Jennifer stated, the reason we need the zoning change at Creekside is because there's this little nuance in the code that I learned actually at LPA from Council Member Gillis as to the reason why, and have now been confirmed that with others that the justification was because in the mid-2000s, there was this huge rush to redevelop everything as condominiums and to build big condominiums, and hotel rooms were being lost, and so this was a way to control the movement of hotel rooms. So in this instance, we're not trying to build condominiums and sell them off. We're trying to build housing for the employees of the hotel. And so we hope that you can see your way to approve it. Where is the... So this is the Creekside. You all know it well. It's on the water. It has the transient units that we're moving. The units themselves will then be redeveloped. A lot of this stuff is in your packet, so I'm not going to go through it in much detail. Of course, we have the land use district map amendment, which is quasi-judicial because it's within the same future land use map. And so when it's quasi-judicial, by evidencing that it is in the same land use district map amendment and it's not a threat to health, safety, or welfare, then at that point you've proven that it is compliant with the quasi-judicial procedure, and therefore we would request that you find it in compliance and vote for approval. Of course, then we have the conditional use approval. As Jennifer's identified, your staff has reviewed all of the requirements of the conditional use process, provided reasonable conditions that we've agreed to, and that we would request that that be approved. That's for the transfer of the 50 units as well as the Islander. All right. This is the information on the Creekside, which, as you can see, the flume designation is mixed use. Village Center is where it's at. We're requesting to go to neighborhood commercial. Next slide. And this is for the Islander, much bigger site, a lot of different flood zones there. So, as discussed, the whole purpose of the Ludd Amendment is to move the property from to allow it to be redeveloped to affordable housing. The property itself, if we take out the ability to convert the hotel to affordable housing, the uses are verbatim the same, and that was brought up at LPA, and that's why we had such a significant vote of approval. It's like normally you'd worry, why? Well, what else can they do if they convert it from Village Center to neighborhood commercial? The reality was nothing. This is the only thing that it allows you to do, is to build affordable housing in the existing building and not waste the building that's there. And so we're going to put back 15 employee housing units, And so that is the goal. There's no ulterior motive here. If we had any other goal, we could just stay in Village Center and proceed. Not very good at this clicker, but one day I'll figure it out. So if you look at the Village Center, this is what I was just talking about. In fact, the floor area in most cases goes down. Your open space is the same. The setbacks actually are a little more for the neighborhood commercial. So we're actually, we are downzoning the property in a sense from a higher, more intense to a less intense, but it still allows for the intended purpose, which is to build employee housing. And that's our goal. We were asked this question before. Why are you building 15 units only? Why can't you build more in the building? Well, you have minimum size requirements for your units, and so the most we can get is 15, and we're not even sure we're going to be able to get to 15. It may be 13 or 14, but because of the 500 square foot minimum size requirement in your code, which just a little suggestion, maybe you want to change that because there are studios and one bedrooms that are not 500 square feet. But the code as it is today requires 500 square feet as the minimum. And so we're going to meet the code to a T when we get there. So as stated, when you review a lot amendment, you review for consistency with the comprehensive plan, which is consistency with the future land use map, consistency with the goals and intents of the comprehensive plan, on the principles for guiding development, and we've provided all of the explanations, and I've just gone through this as to what we're going to do. We've provided the amendment of the analysis of the total parcels, the necessary need for affordable housing. I don't think anyone can argue affordable housing isn't needed everywhere in the Florida Keys, and so with that, we believe that we have provided evidence that it meets the requirements for approval, and for that tab, we would request that you approve as requested and as identified by staff. The next is the TDR transfer. This is the transient units. So in order to build the employee housing, you got to take the hotel rooms, take them out, transfer them over to Islander. There's criteria in your code. Again, this is a quasi-judicial hearing. And so we've documented that they're both scarified, both wet, so wet to wet, and that the units, there's appropriate density at the receiver site. You must provide documentation that the units existed and that this is how they existed as of 2007. You have to document that they are both, that you're going from at least the same type of habitat to a less sensitive habitat. In this case, they're both completely scarified pieces of land, so it's permitted. And you have to show that you can meet all the requirements of the code, and we have done so on our site plan for the Islander. So at this juncture, we would also request, based on the consistency with the comprehensive plan, consistency with the land development regulations, that you move for approval on the second item as it is in compliance with all of the standards as shown here, shown in the staff report provided by the planning staff, and that is the TDR transfer. And finally, once they're transferred, we have the Islander, one of the largest actual properties in the Village of Islamorada, and one of the few that actually has existing density remaining. You go through actually and survey all of the properties in Islamorada. I did this a long time ago actually when Northwood was investing in Chica Lodge, and it was just fascinating to see that it's like overdense. And so the question was there anything that wasn't? And at the time, there was only 2 properties I could find that actually were not overdense, and one of the 2 was the Islander. And so at this juncture, what the idea is to transfer these units over, remodel a portion of the Islander to utilize some of these units, and then to operate solely the Islander as a hotel. Here is the site plan. If you'll note, all of the work's over on the north side. The idea is with all of these buildings is that they all face the water. They all encompass the, like a U shape, and with everything pointing towards the water. So if there is anything, the focal point is out towards the water, not towards the neighborhood. The entranceway, ingress and egress is not changing. We've shown compliance with the traffic. We've shown compliance with ingress and egress. We've shown compliance with all portions of the code. There's a long list of open space, impervious surface, height, density, intensity. Every part we've provided compliance, and we believe that it meets the code to a T, including there's your density calculation. Height, parking, setbacks, open space, buffers, all in compliance. And we've shown compliance with all parts of the comprehensive plan. Shown compliance with roads, stormwater, and all the requirements in the conditional use. So with that, we would request that you also approve the conditional amendment to the conditional use for the Isler. And so, of course, we're gonna request 3 separate votes for clarity of the record, but we would request that you vote for approval on all 3 requests. With that, I'll take any questions, and I thank you again.
Anybody have questions for Mr. Smith?
I do.
Go ahead, Don.
So Bart, I read in here where it talks about it talks about the affordable units being put on the property. When we look at the redevelopment of those affordable housing, I kind of look at it on a building official and not a planning director view. And so I look at a change of use. It's a hotel now. Transient uses, now we're going to multifamily uses, so to speak. So I look at that as having to revamp that site to some degree. And so I didn't see a lot of talk about what was going to happen to that site. Is there anticipation to do any reconfiguration on the site where the creek site is at this moment?
Interior, obviously, we have to do the remodels. And of course, based on, I believe that it's the flood zone, that it will not exceed the 50% rule, because if it did, we would have to elevate and then the buildings would not be capable of reuse. We certainly have to meet all building permit codes for multifamily use, Fair Housing Act, ADA accessibility. But that's ADA accessibility, not this. See, transient use actually has a higher threshold because it's open to the public.
Yes, it does.
And whereas, as you're very much aware, when you then switch to multifamily, it's Fair Housing Act, which is the ADA accessibility standards, which is providing at least 1 unit with ADA accessible features, 1 handicap parking spaces, and accessibility to the actual unit and building, i.e. a ramp or walkway. So to the extent that the building's non-conforming as to those, because this is a change in use, we will be meeting compliance for all the parts that are required under FHA, ADA accessibility, and the Fair Housing Act.
So we're taking a hotel, and I know that people come and go out of hotels. Is it the primary intention to use it for staff housing for the employees of the island?
That is a primary intent, but I will state, and I always state this about any place that uses affordable housing or workforce housing units, nobody wants units to be vacant. The idea that if you have staff that desire to not live in your employee housing, that you just leave units vacant, seems to be not utilizing the scarce housing we have for our workforce, because these are utilizing workforce units. So they are required to make 70% of their income from gainful employment in Monroe County. And so they're certainly at that point would be looking to lease them to other people that are gainfully employed in the workforce in Monroe County.
but there is an anticipation for an increase in staff because you're going from small hotel to a five-star hotel or four-star, whatever it is, and that requires a lot more staff. So, I mean, it's a good thing that we're finding housing for the staff that would be there, but I'm looking in the back of my mind saying 6 o'clock in the morning, there's 20 people that are boogieing from there to go to work in the morning and night shift getting off and going back to the hotel or whatever. So will there be some provision to have, let's say, some transit system that Islander would supply rather than having, 20 cars go down the road and then 20 cars coming back to stay in that hotel?
Yes, to the extent that it is utilized for employee housing for twofold. One of the primary intents is to utilize the HB1 and J2 programs, which are programs where you get workers that will work for a minimum of 1 year. It's up to 2 years.
Visa people.
Yeah, correct. And they're required to you're required to provide a shuttle to and from work and to and from the grocery store, and I think there's one other place. To the extent that we can utilize that, we absolutely are. But then, it also then goes back to that point. If at a certain point, because a hotel is not utilizing it for their own employees and it's other workforce, then it would not. Because, and I'll explain it this way, is a hotel operator also doesn't want 20 employee cars having to be able to park on site. And so, yes, they do intend to be running either a shuttle that they operate or sharing with other operators of shuttles, because a lot of times you can have a shuttle that can do multiple stops.
Is there something in here, I think I read something, but I'd rather you go on record as stating that there will be an agreement that there will not be any use of the hotel until the affordable housing units have their certificate of occupancy and they're in operation, and we're not going to be dangling there with an operating hotel and these affordable housing units being stretched out for another 5 years.
Yes, and I think we actually agreed to that as a condition. If not, we'll put it on the record that we agreed to a condition that the new hotel development cannot be CO'd until such time as the affordable housing units are CO'd at Creekside. Now, I want to be clear though, because our preliminary plan right now is 15 units, but I did catch one room was actually under 500 square feet. So we might actually have to reduce it to like 12 or 13 units to meet that 500 square foot threshold. So, but the idea of saying, hey, listen, the Creekside must be, both buildings at Creekside must be CO'd for prior. Very comfortable with that provision, because if it goes down a couple units at Creekside, I don't want to be stuck that we agreed to 15 units, but CO'd, all of Creekside CO'd for affordable housing prior to CO of the Islander.
You said that neighborhood commercial is very similar to Village Center when it comes to uses. Is there no intent when this thing turns into an affordable housing that we're not going to have any commercial fishing, or we're not going to have any fishing and diving and sailing and renting boat spaces to dock spaces to commercial fishing or that kind of thing on that canal? Is that?
No, there's no intent.
I mean, it's going to be a pure affordable housing.
That's correct.
Project, and it's not going to have some side commercial uses that are going to fall in place later on.
Commercial use, correct. My concern when stating that is you still do have a dock, and you do have people that are going to be residing there, and so you can't stay. We don't want to limit them if somebody wants to have their little
somebody's living there, and they got
it.
Somebody's living there.
Yep.
They have a boat, sure, but I mean, we're not going to be renting out dock space
that is correct. Yes.
Not going to rent it out to a commercial fisherman that's going to leave their boat there.
Correct.
Okay.
Yes.
You done?
So Don, what you're talking about, if he's got a manager that's gonna live there or somebody like that,
Yeah.
a department head, and they
Sure.
have a boat,
Yeah,
then they own the
absolutely.
property there, they should be allowed to put the boat there.
All right.
Anybody else?
Bart, thank you. I appreciate that.
Thank you.
I just want to clarify that we do have a condition in the major conditional use approval that no occupancy permits for Islander shall be issued until occupancy permits have been issued for the workforce affordable housing at Creekside Inn.
Thank you. Appreciate it.
Go ahead, Deb.
I appreciate it.
Turn your mic on.
Sorry. Along the line of Don's questions, is there a way of conditioning that this is not going to be other businesses? I don't know how to word that exactly. That run out of that dock or space. I know you're saying it isn't, and I trust you to say that.
Yeah.
But
And
you
there
have to
is.
look at the future.
And there is, but I don't want to wordsmith it tonight. If you could give us, because we have to come back for another meeting.
Okay.
If you can give direction to provide language as a condition for the next meeting.
Okay.
So that I can get with John and Jennifer and work out that language.
I think that's great.
Yeah, we all understand the purpose.
Can you notate that for
Yep.
us, please?
You know, the elevated building with an AE flood zone, you can flood-proof commercial uses
Yeah.
underneath the building. And we're just looking at something that's gonna be just workforce affordable housing and not. Again,
And understood,
thank you.
and I just want to work on the language with them
That's-
and bring it
that's
back to you at the next meeting.
Thank you.
That's fine.
Yep.
I will.
Yeah, go ahead.
You want me to go ahead and finish?
All right, so, okay, so Jennifer, I'd like to ask a question, maybe Bart can answer this. Why, is there any way that's feasible that if they need this thing to make this thing all 15 and be 500, is there any way they could end cap or something, do something to gain a few square feet or anything, to put a little addition or something to make, so it is 15 workforce housing? I don't know, maybe between you and Bart, you tell me what you.
And let me answer this. The problem with that building is the construction of that building and the age of the building.
Right.
I think we have an architect here who's going to say, we would be scared to death to go through a wall and then deal with the structural integrity of the building and then be having to certify that to the building official saying, we certified that it meets the structural requirements of 180 mile per hour wind load.
Bart,
which
good. You answered my question.
Go ahead, Deb, you want to finish?
Only if Buddy's, you got other things?
done. I don't
You're done. Okay, so, first of all, I think this is a pretty good project, and you answered my question of why only 15 or 14 or whatever that ends up being. Because I, of course, would like to see more, but it's just not going to happen. I got it. You answered the question about the density. I remember seeing that chart years and years ago, that there was hardly any hotels in this town that weren't over density. There was only a very small handful. And so that's good. This idea of you having to change zoning districts, yeah, I understand it, but in the public's eye, I think I'd just like to say that it's not really, you're not actually converting them in the zoning district, you're moving them, but in order to get from A to B, it had to have a zoning change. And you're exactly right on why that ordinance came into existence. There was a move many years ago that several of the small hotels were being converted to condos and into a residential situation, so that was stopped. Your 15 units, or whatever that ends, I assume is coming out of early 300 early out?
That's correct,
units.
and I believe that it's been at prior commission discussions before this about it making sure those are available for this. So I appreciate the prior commissions that work to make sure that we have those.
Okay, and out of those 15 units, I assume, and I found a drawing in here, do you have an idea of how many beds that you'd be providing?
Yes, and I can't tell you from the top of my head, and it will change based on the amount of bedrooms, but you have occupancy restrictions, and so it's really based on bedrooms. I believe on the 15 units, there's about 30 bedrooms. I think it was about.
That's kind of what I was saying.
Yeah, I think that's what it was about, but having fresh set of eyes and thinking about that 500 square feet, I think we're probably going to lose a bedroom or two just because when you lose units, you're required to have a kitchen, and then when you have those, that takes away from that space. So I think that number is going to be reduced. We don't want it to be. We like.
Yeah, I'm sure you could use them.
Yep.
We all can use them. These will be deed restricted, so the income requirements will apply. They're full deed restricted, right? Are they?
That's correct, yes. Yeah, the workforce units, the maximum any unit can do is, I think,
It's
moderate income.
affordable units, though, that we have,
That's
not
correct.
workforce.
They're affordable too. They're still under the affordable restrictions for income and rent,
Yes.
and rent restrictions, so.
Yes,
Yeah.
that's what the difference in that definition is the income restriction. And I assume that these are being deed restricted under, I don't know, that's really not tonight's conversation, I'm sorry, but under medium income restrictions. I think that's all we have.
Yeah, I would just refer to the code, what the requirements of the code, what.
We don't have them defined,
Yeah.
but, yeah.
I would just
they're
refer to
not-
the code, whatever the code provides
Okay,
for that
all right.
restriction.
Is that it?
That's it, unless I think of something else. Thank
Okay.
you.
Wait a second. Steve, do you want to say something?
I'll wait till after public comment.
Okay, go ahead, buddy.
Yeah, hey Bart, I just want to say something because I know there are some neighbors that are very concerned down there. And like when Chica Lodge did their conference center and the other 49 rooms they did, and they went in by the shrimp shack there. So just, I know you guys are going to be very, what's the word I want to use?
Respectful.
What's that?
Respectful.
Yeah, respectful to the neighbors that, live there at the north end of Carroll compared to like Chica's people did, and everything, went off. You gotta make sure the grounds are kept clean and stuff like that. So I'm.
Absolutely.
I know.
I have Ken Reynolds, the construction manager of the project here. He's been already making sure that whatever the organization of it, he remodeled Baker's Cay, which used to be the Hilton at mile marker 100. He also worked in Key West on remodeling the 212 bed and breakfasts that were now the Kimpton properties. And so you want to talk about tight quarters and being respectful to neighbors. There were places where he had 6 inches between his property and the neighbor's property where he was helping to remodel those. So I have all the confidence in Ken and his team.
Thank you, Bart. I just want to bring that up.
Okay, anyone else?
No, just along that same line is the respectful of when you're building of the noise factor.
Yes.
Okay, so I guess we start with anything else from you right now? How about those who are in favor?
Thank you.
Thank you.
I don't have anyone specifically signed up in favor.
Then I guess we go to those not in favor.
Okay, we'll start with Elizabeth Jolin.
Hello, my name is Elizabeth Jolin at 81991 Old Highway. Thank you for your service.
Welcome back.
I thank you. Really appreciate the good work that you're doing. And a couple of quick comments. I do live in that neighborhood, and I have noticed that an addition has been made to this plan that notes that if this is to move forward, that the construction work will go through the main gate, and that's lovely. But I would also like to ask you to have a conversation about why we even want to do this plan. It's a beautiful piece of, it's a beautiful request, and I know that we all adore Mr. Smith and the gentleman here and the owners of the Islander as a community, but I wonder if we can make this more about the community. I know you were all ran on the policy of serving the community, and I wonder how we benefit here, how we as a community benefit, as opposed to just the owners of the Islander. We talk about our need for workforce housing, but let's be frank here. This workforce housing is to accommodate the expansion of a resort. Mr. Smith just commented about the workers will be H-1 visa workers. I mean, those are not local people with jobs. That program is one that brings foreign people to our country and to work. And it's wonderful. It's a way to have employees. But this affordable housing is not serving me, my neighbor, the fisherman. So I just want to, I challenge you to have a meaningful conversation to answer the question of why we are, as a community that you leaders are choosing to almost double the occupancy of a resort, which means a lot more traffic, congestion. We talk about congestion. I mean, this is a congestion problem. We like to talk about property rights, and we all believe in them. And that it might go without saying, but this is an entitlement. We are not taking away property rights from this group if we don't allow them to increase their numbers by almost half. I would urge you to have a conversation about a compromise, something in the middle. I don't know how, with all of the issues that we do talk about, affordable housing, congestion, density, busyness in our town, I don't know how you could approve this, actually. So let me just see if I have any more time left and I have anything else to say. I don't think I do. So I really thank you for having that conversation. I look forward to hearing it play out tonight.
Thank you. Next.
Next is Van Cadenhead.
This is a great idea for the people that own the property. It's a terrible idea for Alamorada. I have the unfortunate history of knowing Leo Samuels, who used to own the Islander back in the 60s, and he sat with my mother, who was the president of the Upper Keys Chamber of Commerce, when the Islander was a medium-priced destination for Middle America. The overexpansion that has already happened on this property is taken away from the ambiance of the community, from the town, and this purports to double the number of rooms. And I can't see how you're going to take 50 motel rooms and take them to the Islander for them to make 50 new motel rooms, and you're going to turn 50 motel room building right units at the Creekside into 15 affordable housing, which means 3 to 1, basically. You're going to have to take 3 motel rooms and make 1 affordable housing unit, you know, just by sheer numbers. And the traffic that you're putting into the village center at Alamorada is already astronomical. And to put 50 more units in there, it boggles the mind, the stupidity of the idea. And the fact that you already have a convention center and you already have a museum there, which are both high traffic, and you've got already had a large expansion of the Islander from what it was in the 60s. A large number of rooms have been added, and this is just more on top of more. And it's good for the people that own the property, but it's not good for Alamorada. It's not good for the ambience of the community. It's not good for the traffic. And you're really not doing anything for the affordable housing if you left all 50 of those motel rooms at Creekside as 1-1s. If you rented them to busboys and waiters and cooks and yard people, maintenance for the Islander, and left them 50, then you would, you know, I could see a whole lot better outcome of this kind of a swap. But the TDRs that you're allowing 50 units of medium-priced motels, which is what Alamorada is built on, because those are the people that come down and rent charter boats. And they're the people that come down year after year with their families. They're not going to be able to come down and afford to stay at the Islander with these 50 fancy schmancy that they're fixing to build. And the square footage is going to increase, the density and intensity is going to increase, and I just think it's a terrible idea. And it's good for the people that own the property, but it's not good for Alamorada. Thank you very much.
Okay. Marnie?
Next is Joe Wishmeyer.
Yes, Joe Wishmeyer, Plantation Key. The first thing I would like to comment on is because we're doing so many tabs at the same time, but we're still only allotted our 3 minutes, just does not seem to be quite correct. The first thing I'd like to talk about is the density. The density of the Islander, you're allowed 6 units per acre. Now, I know that I heard earlier, well, we still have a couple extra that we could do. Yeah, well, that couple extra I don't think equals 50. Now, I understand there's a little confusion in the TDRs. If you get a TDR and put it on a property, voila, you can go from 6 units to 12 units an acre. I think that sets a bad precedence because now any resort or motel it could get like 1 TDR and like, oh, well, now I can double myself in size. That does not serve the community at all, and I think that also should be looked into. You're not going to be reducing the traffic at all because you're going to be taking 50 units and you're going to add 15 more. It was my understanding in the beginning that you were going to just use the hotel units, and that's why they closed down one of my favorite restaurants, Made to Order, which I can't go to because they were going to use that as a kitchen for all the people who were going to be there. Well, I guess that's changed now too, so I don't know if they'll do anything about that. I don't know if you all got a chance to read the Upper Keys Weekly today, but there's an article in there that a company that was retained by Monroe County evaluated infrastructure for the addition of 220 ROGO units. Their conclusion was that would result in 1,037 new daily trips on US 1. Current deficiencies exist on US 1 on Upper Matacumbe and Winley Keys and Islamorada. With 220 new ROGOs, overcapacity issues would be exacerbated from mile marker 79.5 to 86. So not only that, but now you just approved asking for 200 more units just for Islamorada, not including the 220 that the county may get. So how many more trips daily is that going to also add? And you're going to add these units right in the middle of Islamorada, which is already one of the most congested areas of US 1. We all know how the traffic is in there, and you're just going to keep increasing and increasing the traffic flow until you might as well just have a bicycle because that's the only way you're going to be able to get around. So I implore you to make sure that you reconsider this decision because the Islander was already redone several times.
Thank you. Marnie?
Next is Frank Ortiz.
How's everybody doing?
Hey, Frankie.
I wasn't sworn in, I was outside. Is that?
You would need to be sworn in now, yes.
Okay. In the matter in which you're about to provide testimony, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay. How's everybody doing here? Good? You know, I'm listening to all this talk about they're bringing these units from up there to Islamorada, and they keep saying, well, it's wet to wet, it's all compatible. It's not compatible. That's a 4-lane road up there. It's congested in Islamorada, it's packed. And you say it's compatible, but it's really not. The road out there is a whole nother animal compared to what we're dealing with in Islamorada. You know, I live on Carroll Street. My dad lived on Carroll Street. I grew up on Carroll Street. It's, you know, it's going to affect the neighborhood. I was here when the village started with the museum, and they agreed that they weren't going to bother us there on Carroll Street. We gave them the middle of the road. We gave them variances, all the properties, so they can keep growing into this big monstrosity. I mean, I think it's just got to stop, or just, you know, some kind of compromise with just expansion that's going on. I'm a fishing guide. You drive down the water and you look, and it's just like building after building after building, and the environment is just really getting hurt from all this. It needs some relief, and I think you guys ought to think about this. really put a lot of thought into this, because they keep saying it's compatible, it's the same. It's not the same. It's in Tavernier. It's not in Alamorada. You're bringing all that down to Alamorada, which is already packed. I mean, the traffic, the employees coming in and out of there. I don't know. I think that's enough, I think. Okay?
Thank you, Frank.
All right, thank you for your time.
Marty, anybody else?
You know, I do have one more minute here, right? If this does go through, I was here at the village meeting when they were going to do the conference center, and they agreed not to disturb us on Carroll Street. And I came to fight with this, and all of a sudden they said, no problem. They put a buffer there, they put a swale there, they put trees, and they made it look beautiful. I didn't get it in writing. I made a mistake, and I didn't ask for it in writing. I agreed. The previous owner was over here, and they said, absolutely no problem. If it does go through, that Carroll Street is to remain undisturbed. As long as I'm there, please, it's very important that you save some of the community, the neighborhoods that are so vital to this whole area. Thank you.
Thanks, Frank.
Thank you, Frank.
Marnie, anybody else?
Yes, next is Sue Miller.
Tinkerbell, come on up.
Sue Miller, my first comment is I object to the fact that I, representing the Alamorada Community Alliance, will only get 5 minutes. I think that when I'm talking about 3 different public hearings, that it is unfair to restrict me. So I'm going to start, and you can just turn me off whenever you want to, and I won't be happy.
Okay.
The entire justification for this is first about the zoning change. The entire justification for the zoning change is to allow for the redevelopment of the motel structure in conjunction with the Islander Resort. There have been discussions about mending our regulations to provide for workforce housing as the primary use for affordable housing, but right now we have affordable housing in our code. We don't have workforce housing, and so is it going to be a contingency in the contract that it be workforce housing and not affordable housing, not the standard affordable housing as provided in the Alamorada Code? Our code section 30-506F regarding the transfer of hotel units states, the conversion to affordable housing on the sender site shall be completed prior to the issuance of a building permit on the receiver site, or the hotel units on the sender site must be demolished. Are we just ignoring our code now? To accomplish the zoning change, the first reading, second reading, and approval of Florida Commerce will all take place, and the building permits for the Islander will have to wait until the zoning change is completed if we follow our code. So I don't understand how they are changing our code in the use of it. According to our code, the sender site redevelopment must meet the density requirements, so I understand that it's going to be 15 units per acre or less. But without a site plan in our agenda, we really are left to guess whether there will be any affordable housing. You haven't tied these 3 together except to restrict the length of time I'm allowed to talk. There's no contingency that one has to follow the other, that all 3 have to take place. There is no guarantee that they'll ever do affordable housing, is there? I'm going to go on to the next one, to the major conditional use. They had to do a traffic study. Clearly, the traffic study was based on the 2021 study that was done by the county, not the 2023 study that the county didn't approve, which would have completely eliminated the opportunity to do what they're doing, because we would then fall under the level of service allowable. And so the Upper Matacumbe is classified now as a level of service E with a maximum reserve capacity of minus 883 trips. And this traffic study that was done increases the number of trips to by 432. So now we're over 1,300 in arrears on Upper Matacumbe. Does that tell you something about how much we need to look at traffic in this town? And why don't we look, when we're only looking at the level of service for the entire Monroe County, we never look at other projects. We're just saying, well, this project won't take us over the limit for all of Monroe County, but we're ignoring what's going on everywhere else. We're ignoring the trips generated by the new Publix in Tavernier, by what happens when Postcard Inn comes back online. A condition created by staff, no occupancy permits, doesn't work for me at all. The building, there is a building that's shown that's in a V zone where you're not allowed to build in a V, you're not allowed to transfer into a V zone. There's no signed and sealed survey as required to tell us exactly what the square footage is on the receiver site. Mr. Smith went to law school to learn how to baffle the government. I went to school as a math major to learn how to calculate, and I will tell you that calculating the allowable density, assuming there's an existing 114 units at 6 per acre, you use up 19 of your acres out of 20. So then you have the non-residential space, and that takes up another 2 acres. So now you've used up all your acreage. There is no room to move 56 units based on the density calculation that a math major uses. I know that lawyers use different numbers than math majors do.
Okay, I let you go over, Sue, so don't be mad.
Thank you.
Okay. Anyone else, Marnie?
No, ma'am.
Okay, Bart, you better get up here and defend yourself.
Yes, so most of those things don't even require a response. They're simply incorrect. The staff has provided the correct calculations, including with TDRs. The transferences are being done in conformance with the code. One point I do want to point out is that actually our intent for those units is 50%, about 50% are for managers, which are not H1, and couples that will be both working on the site, which are also not HB1. So the current design has 5 managers that will be in that building, and 2 to 3 for couples that we also would have at that. The reality is that you have 2 hotels right now. Both have managerial, cleaning staff, and every person. You combine them into one hotel, you are reducing staff needs. The other part of it is, instead of having staff that has to come from Homestead, they are not having to drive down the Florida Keys. And so this will actually reduce traffic, reduce the amount of employee demand, and that the units will be utilized by people that are a part of the community. Even people that are here for a year are a part of our community. We are one human family, and so I wholeheartedly agree with that statement. Finally, these are quasi-judicial hearings. We must provide proof that we meet all the provisions of the code, and that if there are any parts that we are shown to not be in compliance, then we have to provide some type of offset. The parts that have been identified, such as providing the COs, providing the conditions that we've agreed to have been done. And so therefore, we would request that you vote for approval, and I'm here to answer any other questions you have.
Does
Thank you.
anybody up here have any questions for Bart? Go
I do.
ahead, Don.
I do, I have a couple.
Go ahead.
Will you address the V-zone issue that Sue brought up? Because
No
there-
units are being transferred into a V-zone.
no units are going to be in the V-zone.
That's correct.
Okay. We're transferring, there's 50 units at Creekside,
Correct.
and we're transferring 50 down there.
Correct.
What are we reading about 56 units?
There's another 6 units we're going to take from the other Islander and transfer. We haven't applied to transfer those yet. We have that Islander Bayside. We're going to transfer 6 units from there, but we just haven't applied on those yet.
Those are the ones that are across from the Turtle.
Let him
Correct.
finish.
Yep.
And
Let him
Devin,
finish
let me,
first.
what happened, so what are those 6 going to turn into? Are they, that are coming from across the way?
The same thing, hotel rooms. They're already identified on the site plan for the amendment to the conditional
And what's going to
use.
happen to the ones that are being transferred, those units?
What do you mean?
Are they going to turn into
They're
affordable
excess,
housing?
they're excess units that aren't even being utilized at this juncture.
Oh, they're excess
Yeah,
from what happened
correct,
there?
Correct.
Okay,
yes.
so they're TDRs that are in excess?
They're just sitting, yeah, they're
Okay.
paper.
All right.
Yep.
Can Deb go?
Yep.
I just have a question
ahead.
related to the units, and then you can have it back.
Go ahead.
Okay, so I thought the 6 units, and if I'm wrong, I understand. I thought the 6 units were the ones that came from, what was the little motel on the canal, on the bay side just north of there? The Islander didn't buy those?
No.
You know where I mean? What's,
Yeah, Chica bought those.
Chica bought those.
Yep,
Oh,
yep,
okay, I'm
Chica.
sorry.
Yeah, they're from,
Okay.
they're
That's
paper
it.
form from
That's
Bayside.
fine.
Yep.
Mr. Pender, do you have anything? No. Anything?
I'd like to know if anybody from the public would like additional time, if they felt like they were cut off and had some other things that they wanted to discuss.
That's up to the mayor.
Oh, great. Well, Mr. Quick, how does that work, since we combined them and everything?
I mean, they've been given an opportunity to speak. If you all want to give them more, that's fine. I would remind people it needs to be based upon competent, substantial evidence, not just sentiment. That is what is required to support any decision
Okay.
of the council.
Did you guys understand that? Do you want to have another couple minutes to speak? Of course you do. Come on up. Okay, come on.
Let's wait, before he gets started, why don't we establish how many minutes so that the clerk can set a timer for it?
Two.
Okay.
Two.
My name's Frank Ortiz, and again, I just want to say, if you guys go forward with this, that Carroll Street somehow gets written down on paper, there will not be no access through there at all. I don't want to come back here another couple years and say, oh, here they got their museum, and here they're going to come plowing through here again. Here they got their 50 units over here, and you know what? We changed our mind. We need to come through here. We don't want the traffic through there. I made a deal with the previous owner, and I didn't get it in writing. I would like it on paper, so I don't have to deal with this. I plan on dying here on Carroll Street. I'm not moving. This thing just makes me all worked up. I feel like I want to leave, and I've never felt like that before. It's so sad what's going on in this little town that I grew up in. I was born here, like I said, and it's just sad to see what's going on. And just, you know, if they're going to come through, which they're probably going to come, go ahead and bulldoze right in there and do whatever they're going to do. Please, Carroll Street's got to be eliminated off the whole picture of this, like they agreed to when they got the village. Yes, sir.
We have agreed that Carroll Street is an emergency ingress and egress for fire only already. It's a condition.
Okay.
And we'll get it in writing.
Okay.
Okay?
All right.
Thank you. Anyone else? He's faster.
Yes, I guess Joe Wishmeyer, Plantation Key. I guess then one of my biggest questions was if you're not going to transfer anything to Creekside, but you're transferring all 50 units from Creekside to Islander, where are the 15 permits going to come from for this workforce housing?
Out of BPAS.
Out of BPAS.
They'll have to come out of the affordable housing BPAS.
Okay. Elizabeth, did you want to come back up? Elizabeth?
Elizabeth, 81991 Old Highway. Again, we're pretending that you've passed this. You haven't, and that discussion needs to happen. Why are we even entertaining it in the first place? I mean, Frank is like the perfect example of everything that we hear on this dais about the old timers, he's the old timer. He's really old. And I mean, not Frank, but his dad. Frank is old, and then I'm a little bit older than he is, but this is what we're talking about. I also wonder if you can even entertain this conversation with so many questions that you have about, I mean, you know, Bart is not going to be standing at the Islander gate for us to go and say, hey, Bart, it's too noisy, he's not going to be there, even though he is a lovely man, right? This is not Bart's project. He's just representing the owner. I wonder if you might, well, I mean, obviously, I think it's a bad idea all around. I don't know how you could justify it. I don't even know how you can entertain it without this affordable housing project laid out in front of you with all of the details. But again, you haven't even gotten that far because you haven't even made a decision about whether this makes sense for our town. So I appreciate the extra time.
Thank you. Anyone else? In 2 minutes, not 22.
I want to show you that I'm a pack rat. These are sales brochures that I had when I was a realtor, and I haven't been a realtor for over 20 years, close to 25 years. The total size of the property appears to include residentially zoned lots not eligible for hotel use. The calculation of non-residential, where did the square footage come from when calculating density? There's no documentation as to the size of the museum, conference room, multiple restaurants, retail space, offices, just a total number that seems significantly lower than reality. There's no verification of the permitted number of hotel rooms at Creekside. That's why this comes in, because the sales brochures, back when they were originally sold, didn't have the same number of hotel rooms that they have now. I went and checked. There are no permits to add to those. The applicant using the Monroe County requirements numerous times. We're Alamorada. We don't use the Monroe County requirements. The parking for Monroe County code is different than the village code. So the parking was based on county code, which requires less parking. No parking was shown for 2 restaurants and a bar. The site plan shows 89 new units, not 56. Some appear to be the result of eliminating guest suites and converting them to non-residential space, or what else. They're not being demolished. The rooms are being rebuilt at another location. Non-residential BPAS should be required. The density calculation should be updated. The TDR ordinance, no survey of the receiver site to explain the calculations. The staff says they're 22.8 acres. The property appraiser says 21.12. The traffic study says 21.83. The staff apparently included residential lots, no documentation as to the existing non-residential square footage to determine what the remaining density is. According to my calculation, 114 units at 6 per acre is 19 acres. 20,596 non-residential at 0.25 floor area ratio is 1.89 acres, leaving 0.3 acres or 3 new units allowable. Left for added units all depends on the required survey that is not provided in the agenda.
Okay, we get it. Thank you. Okay, thank you. Anybody else, Marnie, or can we?
There's no one else signed
Okay,
up.
Now does Bart get to rebuttal again
Yes, I
before
would
we
say
can
since
talk?
we opened it back up, we should provide that
Okay.
same opportunity.
You'll waive? Okay, so now can the council have a, okay?
Absolutely, yes.
Who wants to go first?
I guess I will.
Okay.
So I had a very good agenda brief with the staff when the agendas came out, And I had a lot of questions about this, and appreciate the time and the support that staff gave me to try and get me up to speed, because it is a very complex issue, notwithstanding 700 pages, but the nuances, the inconsistencies that I tried to grasp. I feel like I grasped the concept. I just don't see how it's going to be beneficial to the community. I see it being more beneficial to the ownership. If you'd like to address that, I'm happy for you to answer that. I do have concern for the adjoining community, namely Carroll Street. They've had their own issues in the past. I think they're still having issues with the History and Discovery Center, with weddings and other events that may spill out a little bit late or a little bit loud. I'm also concerned that we're getting rid of another small business here, another small ma and pa motel, and maybe that benefits other small ma and pa motel owners by eliminating some of those. But as Frankie alluded to earlier, for people like him and myself, it's a smaller demographic that's coming to the Keys that's going to be able to afford $1,000 a night hotel and $1,000 a day in fishing. And so I think that we're losing that aspect in this community by getting rid of these, let's say, more affordable hotel motels. There are too many inconsistencies. I have more questions that arise just by delving into it. There are terms in there that I don't even know what they are, first to admit it. So I'm not comfortable supporting this, and I think we know that I am opposed to overdevelopment, and that's what this seems to be to me. Okay, well, I'd like to jump in there too, because it seems to me I would like for you guys to come back with something better, because I feel like it's all on this side for you and we're getting this, and that is how I feel. I own a business in Islamorada. I'm born and raised down here like everybody else, and no, I'm not going to go on about my family, but I'm just saying, you're supplying housing for 15 people, yet you're putting 50 hotel units on there. 15 people aren't going to take care of 50 guests or 50 rooms. So now we have an imbalance where now we have more people who are going to be looking for homes down here or traveling back and forth on the road. I do have a lot of questions like Steve has. I just don't feel this is being presented where it's balanced, if that makes sense. I don't feel like everything that could have been done has been done. I almost would like for you guys to find more housing, because 15 units to me doesn't really do much. And I love the Islander. I have my fishing tournaments at the Islander. They're great people. It's a great resort. I question too, you're squeezing more into this hotel that's already laid out beautifully, but that's not my place to determine. That's the owners and their decision. But I'm not getting the balance where this community benefits. And I know Carroll Street, and I know that access roads was utilized when the convention center and the museum were built, and that's not really fair to them. So I don't think everything was done or presented that balances out what's even for me. So, anybody else?
Here lately I've been tagged as the Concrete Coalition guy, and I'm not sure why. I'm a home builder, but I look at, I tend to agree that's downtown Islamorada. It's the small area. It's a lot to add right there in downtown Islamorada, and it's a little to get with 15, 14, 12 affordable housing units. They really still have concern about the Creekside and the redevelopment on the Creekside area. There's absolutely no stormwater management on that site. It's a 1950s, 60s site that has, every drop of water that hits there runs right into that canal. It's a gorgeous canal. I used to own a piece of property on the corner of Sunny and Bessie, and it was just full of a seahorse and stuff, and I don't see that anymore. And I know we're doing a lot of good things and cleaning up our environment and stuff, but this doesn't help that area. Frankie's 100% right. We're moving a small hotel in a 4-lane, 5-lane, 6-lane area, actually, because we have the old road, we have the highway that's there, and it's a divided area. And all of a sudden, we're shoving 56 units, which is confusing to me how we can approve tonight 56 units when we haven't addressed where the 6 units are coming from. And you told me where they're coming from, but I don't see that in the plan here. And maybe it was addressed and maybe it wasn't. I don't want to deny this, but I sure don't want to approve it the way it's presented. And maybe Sharon said it the right way. Maybe we need to go back to the drawing board and really think about this. Frankie's starting to look more and more like his dad, and damn it, I hate that, and, but I love Manny and Issa and those folks, and I think, this Concrete Coalition guy has got to say, we got to think about this in that area. That's downtown, heart of this city, and it hurts me to think that we're going to have just a ton of traffic right there in that little area. The Lorelei is successful, the Chica is successful, and every time the Chica has something going on, they got to find a spot to park. And I think the last time they had that, we parked off site and were transferred in. And I got to think about this. I got to think about this.
Thank you. Buddy or Deb?
So I think I alluded to it, that I don't think 15 is enough, but I think 15 affordables, is enough. I expected a higher number, but I also know that our inclusionary zone ordinance probably came up with that square footage of requirement. I know there's a correlation, and I don't remember enough of the details in order to say that's true, but 15 is light, 12 is even lighter. I understand why it's 15 and why it's 12 in your plans. The other stuff, I think we've made a stronger presentation about protecting Carroll Street. It's got to be a constant reminder because, no offense to the Islander, but they flip managers on a regular basis. And the new management doesn't remember the old rules. And so it's like a lot of stuff, it's every time you change people, then you need to be reminded again of what the rules were and how to behave. It's getting harder and harder for a small motel to exist on their own. So Islander has owned the Creekside property for a long time now, and I can't address how their operations have been going, but it's very difficult to run a small motel anymore. It really is. The number of units, that's part of the reason I asked about how many beds, is because the number of units, if you've got several beds in each one, you're working it as a dormitory style, kind of. More than a dormitory style, but if you're taking one unit and putting 4 or 5 beds in that unit, that's what this plan looked. Okay? So just give me a minute and you can have the floor. You said that 50% of them, those units, I'm sorry, I'm all about the affordable side of it. I always have been. 50% of your units would go to managers or couples. They have to meet those income requirements. under the affordable, we have, not under the workforce. We do not have the workforce ordinance in our coffers at this time. We have the affordable ordinance. There is a difference. Okay? Okay, I'm done.
Wait,
for
before
now.
he goes, Buddy hasn't had a chance.
So,
Turn your mic on.
you know, I'm sitting here thinking about these guys, and you know what? K Clubs was gonna, bought Creekside Inn, was gonna build all condos along there, okay? Until they went out. So here, these guys are following our rules. That's what I don't understand. No, they're following what they said. And here's the thing, the village is a fishbowl. You can't bring anything in and you can't take anything out. So this is what the people at Chica Lodge had to go around and buy Conch Inn, whatever it was, all these hotels to get the rooms to do the 49 units. I mean, this is redevelopment. And first of all, the Islander, I knew Leo Samuels very well. And I know where Frankie grew up, and that Frankie was one of the reasons why I asked about the residents and Elizabeth, because Carroll Street, I know is very sensitive, but it's one of the biggest FAR properties in Upper Matacumbe Key, if we've looked into it. I know the size of that property. It's all ground level, okay? Leo Samuels didn't go 3 or 4 stories hotel, 3 or 4, just like America was then could go higher than the 35 feet. But, it really gets me that Bart is working with Jennifer, okay, our staff, and they're I just don't understand it. They spent all this money and this time working on this. How many years ago, Bart, did you guys buy the Creekside Inn? A couple years ago?
Oh, it's more than 3 years.
Okay.
Yeah.
Yeah, it is.
I can't recall things further than that right now.
So,
3-4 years.
My thing is, people follow our procedure. They go do what we ask them to do, and then they come in here and we turn them down.
That's not true. That's not true, Buddy. I mean, there's a balance.
Buddy, nobody's turned them down.
No, I'm just saying, what I'm saying
Can I address
is, it's a lot of times, people, I know for a fact that they came in, they followed everything, and then once, and Jennifer was not here, I'm talking about some previous planners that we had here, and then they come in and then they got to do something else. And then when they come back, I've had people crying in the parking lot, okay, before I was ever a council person. All right, Betsy J. Cox, when she did the Bad Boy Burrito, I mean, she did 2 traffic studies. Why other people put things in Upper Matacumbe didn't have to do any traffic studies. What is good for the goose, and Van commented the other night, is good for the gander. We gotta follow, we gotta have some consistency here. All right, I understand there could be things we can tweak or we can do. I'd love to see them build a few more affordable units. But anyways, that's all I have to say. I just say that it is one of the biggest FARs, floor area ratio properties, all right, in Upper Matacumbe, actually in Alamorada, maybe even outside Alamorada, but this is redevelopment, the way I look at it. Anyways, I'm finished, Bart.
Go ahead.
Okay, to start with, this is quasi-judicial. The requirements are to meet the code. We are meeting the code. What Islamorada gets is that Islamorada gets redevelopment. Right now, these properties are not providing employee housing. What you're getting is not just 15 units. Right now, the plan is 60 beds, so 60 employees. That's going from 0 to 60. You are right, Don. That site will be required to meet the current codes for drainage.
Yes.
For every part of the code. When you redevelop a site, drainage must meet the current code. There is no current drainage. It will meet the current code for drainage. Meeting every code requirement means that no water can be discharged from the property into the water or onto the street. Not happening now. When you look at what is happening at Creekside, you will see 100% improvement. You will provide employee housing for 60 people, and right now it's 0. That is an incredible benefit that is not required to get a conditional use approval for the redevelopment of your hotel. When you meet the standards for redevelopment, then you are entitled to the permit. This is not legislative, it is quasi-judicial. Meeting the standards means entitlement to the permit. So stating we need something outside of those requirements, that is not how the code is provided. That's provided for the consistency. We're providing employees. We're going above and beyond. There's one thing I want to bring up because there's the neighbors, Carroll Street. Ken's met with a bunch of the neighbors. He met with Barnaby the other day, who's a neighbor. Barnaby was concerned about noise. He showed how these buildings face forward, so there's not going to be noise. We've agreed on that it's not for ingress and egress. It's a fire exit only. We are actually going above and beyond on that buffer. And we can provide that buffer so you can write into the code at the next meeting. But we're going to do zoysia and calusia. So, big high bushes that are this just basically soundproof and thick, because the idea is to give more of a buffer to them than exists now and will provide more of a buffer than's ever been there. So we are very cognizant of providing these things to the neighbor. They are part of the plan. They are in the conditions. And so what I would ask for you is to look at your code, look at the requirements that have been met, look at the things that have been done above and beyond it, and based on the code and the requirements of the code under a quasi-judicial, follow the code, approve it, and we will stand by everything we've done. Thank you.
It's not that I don't think you're following the code. First of all, I'm wondering where you get 60 people in 12 rooms.
No, there's not 12 rooms. Units. There's multiple bedrooms in each unit.
What makes you think, what happens if I wanted to apply and I'm by myself?
What?
So you're going to say I got to get 3 roommates? I'm just saying, you're only going to let people live there who have 3 other people with them?
The intent is these are for employees.
Oh, no, thank you. Okay. Well,
It's our employees.
Again, I know we have to follow the code and everything, but it just doesn't make sense to me what we're getting and what you're getting. That's just me. I'm balancing it out, whether it's the code, I don't care what it is, it doesn't make sense to me at this point. I don't feel we're getting what you're getting. And you don't have to agree with me, and nobody.
And what are you looking for the village to get then?
Well, first of all, do something about widening the road in Alamorada to make it so it's not, and then we're not getting, I don't think you're housing your people for your expansion. You're not helping Alamorada with the people who already need housing. That's the way I'm looking at this too. I mean.
That's outside the scope of the review, and that's outside the scope of what's done.
I mean, I just have a problem with it, so.
Well, then we need to change our code, what you're saying, Sharon, because that's not right if they're following the code.
I get the code thing. It's not that I'm disputing the code. It just doesn't make sense to me how this is balancing out. That's it.
Okay.
Buddy and you are alluding to adhering to everything to the code, but isn't what you're asking is to change that code? Because the way that it's set up now, it doesn't fit the narrative? Okay.
No. This is the procedure for a conditional use approval, which is when you exceed a certain threshold, you're required to get a conditional use approval. It's reviewed for these standards. If you meet these standards, then based on the evidence provided, which we provided the evidence, you are entitled to the permit.
Okay, and then just one other separate
You're not
question.
changing the code.
You had mentioned when you started that some of those units would be going to the HB1 folks?
Possibly. They could all be people that are not.
But if not them, then where do those guys go? Because you're still going to hire them.
No.
You're not necessarily going to hire the HB1s?
No, not necessarily.
Oh, okay. I thought you just
By the way,
implied
if
it
you
was.
do, you're required to provide housing. So please, and you can't look at who's occupying a unit. Like as a government, like I would be very cautious under the Fair Housing Act to say, well, who's going to be in a unit? I mean, that's a very slippery slope right there.
Yeah.
So I would very caution about making statements about who's occupying housing.
Okay. Don?
So, Jennifer, help me with this, please. So we're going to be approving the transfer of 50 units, but we're approving 56 at the Islander?
So the site plan shows the 56. They have not approved for the the transfer yet for the additional 6, but they wouldn't be able to obviously build those until.
But
So
would
t-
we be approving 56 if we
Yeah, so-
approve this?
So typically, we ask them to add everything that they want on a site plan, so that, in a conditional use permit, so that they don't have to come back for those things. They will have to come back for the transfer, but then they won't have to amend their plan once that piece is, if they don't get those transferred, they can't build those additional 6.
That's correct.
Well, and on all 3 of these requests, staff is recommending approval. So staff has taken, how long have you been working on this, Jennifer?
This was on my desk when I got here for the village 2 years ago.
So at least 2 years. I mean,
That I-
somebody worked,
that-
you've worked
and
on it for 2 years.
That I was working,
Somebody
somebody
worked
else
on
was
it
working on
before
it
that.
prior to me, correct?
You know, one of the things that we don't have in a code that the county has is you have to have a community meeting before, which lets the community weigh in at that time. And you've been to many of those, and I've been to many of those. You've got to schedule the meeting, the public has to come. We don't have that. Maybe we ought to think as a collective of having something like that. But as I've watched so many of these, we have to base our decision on the facts that are presented and the testimony that is presented. And then we look at staff's recommendation. And I think we're making a mistake if we go off of, if we just don't look at what staff is recommending approval on all 3 of these. It's redevelopment.
I don't think so.
Yeah.
So,
That's all there is here, Don.
so part of the reason that I asked, I'm the one that brought up the bit about how many beds.
Yes.
Because I could see in the drawing that some of the units, it looks like, and I know it's just conceptual because you got to figure that out yet, but looks like some of the units would have 1 and others might have 6 or 5 beds in them.
Can I answer that? So the
Sure.
maximum occupancy is 2 beds per bedroom, and so we have
Per
3.
bedroom.
We have 3
I'm talking
bedroom
about the
units.
units.
Yeah, so we have 3 bedroom units, so they have 6 beds. So
I
there's 2
know,
bedroom.
but you,
Yeah.
okay.
Yeah.
I understand
Yeah.
that. I do understand that. If you want to clarify that for others, I
Mm-hmm.
do understand. You're talking 2 per bedroom.
Yep.
Some of the units have 3 bedrooms, that's 6 people.
Yep.
Or they're small, so you've got maybe 5 people.
Correct.
But you have
Yep.
others that have 1, that might be for that manager and his wife. Or
Correct.
her
Yep.
wife, or her husband.
That's the current setup, yes.
You know? But that is why I was getting there, is because you only said that you were building maybe, hopefully, 15. But you're going to house more employees than that.
Absolutely. We would love to house as
Right.
many as we possibly can.
Of course you would. Let me know if you have any left over. Oh, no, sorry. But that is why I brought that up, is because 15 doesn't sound like a lot.
No.
And because if you're doing one-on-ones, 15 isn't a lot. You're going to be hiring more than 15 people.
Agree.
So, yeah, I don't know how, it's very difficult to get around the fact that more units in the center of Islamorada is going to increase traffic to a degree. The fact that they pull them off the road and go into the property is different. We would have, Jennifer, would we have another site plan approval after this, or is this it?
You would not see a site plan approval. They would come to planning staff with the site plan approval for the Creekside units if they did any exterior remodeling or addition or anything like that.
What about the Islander?
No, this is the approval of the
This is
Islander,
it for
unless
the-
they made any additional changes.
Because I didn't count parking spaces, I didn't do all the detail.
We did that for you.
Thank you. I appreciate that.
We're overparked.
And you will have events there, so there needs to be an allowance for parking because of they're not in the motel room. That's some of the other redevelopments that I've seen, you know. The letter of the law said that that's all they needed, but that's not all you need.
Yeah, we have, because they're operating it, we have more than sufficient parking. We are confident in the parking numbers.
Okay. I don't know. I really would like to approve this. I worry about the affordables.
You done?
Yeah.
Go ahead, buddy.
Yeah, so, I don't know, Chica they built 10 rooms. They got 40 people in those 10 rooms. That's what the number was. And this was done before I was ever on council. Chica was. It was already approved.
All right,
Mayor,
so,
Can I get a question?
go ahead.
Jennifer, have you in any way calculated what the mitigation fees will be for the
Can I
additional
sug-
affordable housing units that may be required?
We have not. We don't typically do that till they apply for a building permit stage. We felt at this stage it would be too early because we did not know if the council was going to approve this number or a different number, so we don't usually do that until building permit.
Are there conversions of some of the rooms that are existing on there into other spaces?
Yeah, back of the
Anticipated.
house space, like basically storage. We're converting things to storage.
So those things would also trigger some more
It's accessory.
mitigation fee for affordable housing. So the shortage of the units in mitigation fee plus whatever changes over there, back of the house or whatever. Okay.
That's correct. And just to put your mind at ease, like, we would certainly agree, we will have at least 10 units at that property with, a minimum of.
At Creekside property?
Yeah, Creekside.
Okay.
Because like, I don't want to commit to 15 because like I looked at the last plan, but if you wanted to put a condition on there, a minimum of 10 units must be CO'd with at least 20 bedrooms. I think we could state with confidence the plans will provide a minimum of that. We are going to maximize it out, but if you want, we are agreeable to that condition to put a minimum threshold, 10 units, 20 beds.
So there's still in my limited knowledge, there still would be additional mitigation
Yes,
needed
yeah,
for
of course,
affordable.
of
Because
course, yeah,
I
probably.
suspect that the hotel rooms that were at Creekside were 300, 350 square feet, give or take.
Yeah.
And the new ones you're going to build are a little bit bigger. And if I remember the code correctly, and I apologize, I didn't ask you these questions in our meeting. The difference is you have to pay a mitigation and/or building fee. And I don't know how that applies directly to what they will be doing at Creekside in building,
That's correct.
remodeling the units.
That's correct. It's a square footage.
based on-
It's a square footage or fee, and so certainly we're going to provide all the square footage, maximize the square footage at the Creekside to provide that. And then whatever else we're going to provide by fee, correct?
Yeah, well, yeah, this is where, way back, I thought we made our mitigation fees say that mitigation ordinance say that you had to build. But we put a stipulation in there that you could pay if you could not figure out how to build. But it turned out that it wasn't as strong as I thought it was, and we allowed people, I'm not picking on you guys, we allowed people to not build and give us the money instead, and the money doesn't get the job done. So that's why I'm asking these questions. That's why I push as hard as I do to have as many units and/or beds as we possibly can.
And we are in the same boat. That's why we'll agree to the condition to put it at 10 units, minimum 20 beds. But I just, until the final, because when we go to life safety plans, getting out of ingress and egress, two means of ingress and egress out of a unit, you want to make sure those
So
are met.
the square footage up there, you're converting if I was recognizing the building sizes.
Yep.
You're converting the existing buildings, like the restaurant buildings, into apartments also?
At Creekside?
Yeah.
No.
You know, like the made-to-order building.
No, it's a different parcel even. It's not even the Creekside
Well,
parcels.
what are you doing with
It's staying as is. It's leased, isn't it leased?
You kick the leases out, but
It's not even,
it's not part of the project.
it's not part of anything, yeah, that's being done. It's a
But you
separate,
own
it's a
it.
separate parcel, but yeah,
You own it,
yeah.
yeah.
Not me, but.
Sorry,
Correct.
you're.
Correct. It might
you're-
be sold off separately, it may be released. It's not part of any part of the identified
So,
project.
where I'm going with this is you've got another parcel that you could build on for affordable. I'm just throwing it out there. You do.
I'd be happier with that.
I mean, it seems to me that we've
The
got.
more affordable, the better.
It seems to me that we still have a lot of questions. We still don't even know how many affordables. I don't know how we can move forward with this at this time.
That's because you judge by the code.
Well, the exact
And the mission.
numbers, the exact numbers that I'm pushing him for really isn't part of the item in front of us. That doesn't mean that we can't have the discussion, because it's a good time to have the discussion. But it is not part of the code that we actually have in front of us, is the problem.
It really doesn't matter if there's 2 or 20, because the code is going to require them to either build or mitigate for that.
Yes, they will.
The affordable units during the redevelopment.
It's a requirement of redevelopment, whether it's a conditional use or not a conditional use. If I'm just building back a non-residential space that's 1,000 square feet, that doesn't even rise to threshold of a conditional use, I still have my affordable housing requirement.
Yeah.
Conditional use just means that it's the redevelopment or the development is of a nature that it's at a level that it needs to be reviewed by the commission. But it's still the same criteria for meeting the code that is for a building permit. If you have a 1,500 square foot office space and you want to build a new 1,500 square foot office, the same conditions are going to be required. You just don't go to the commission for it.
You know, Steve, they're looking at the code. I'm not looking at the code. I'm looking at a balance, and so that's why I have a problem. And I know you met the code, and I know they said yes.
And I'm looking at the mission, and I don't see how this
Yeah,
helps
listen, I'm right
anything
there
up there.
too, but, you know, I mean, that's what they're gonna vote on is the code, where I'm not.
That's what I'm going on.
I know, okay, so.
How can we change the code?
I'm not
Okay.
asking you to change the code, doesn't
Okay.
mean I have to like it.
They're following what the code is.
I get it.
Okay,
You-
all
I
right.
get it. I
Okay,
get
so
it.
maybe we gotta change the code in the future.
Well, that's
So
not helping us now.
Maybe we need a little guidance from our attorney here. We are supposed to render a decision based on the testimony and the evidence that's been presented to us today.
Correct, based on, the standard is based on competent substantial evidence, whether it supports that they've met the criteria that's set forth in the
Not
code.
how we feel necessarily, but what, are we meeting the code? And has our planning director reviewed this and recommended approval? And the testimony says that these guys have met the code as it relates to transfers and it relates to density and intensity and parking and all of those things, right?
Correct, all based on the record before you, testimony, documents that are part of the record evidence, yes.
I get that, I'm functioning on feeling, I get it, so you guys vote how you want, I'm gonna vote my feelings, and it's still gonna pass, or whatever, so. And do I have a motion?
Well, just one more thing. We keep talking about how this is just redevelopment. This is new construction
I
we're
know,
talking
it's
about.
not redevelopment, it can't be, it's physically impossible, you know?
They're not going outside the footprint of the property, okay?
It's unit to unit. It's
Yeah,
in the city.
I got it, you guys, I got it, so, where do we wanna go, you guys, somebody wanna make a motion?
Well, we have to make them independently,
Correct.
right?
Yes.
So on J, which is the change in the zoning, I make a motion to approve as presented to change the zoning.
I second it.
Marnie, call the roll, please.
Councilmember Deb Gillis,
Yes.
Vice Mayor Don Horton,
Yes.
Councilmember Steve Friedman,
No.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
My feelings say no, even though it passed, so.
Okay, passes 3-2.
Okay. The next one? Do I have a motion?
The next one is the major conditional
Yes.
use.
What happened, Don?
Amy, what happened?
Well, I thought you were not on the Concrete Coalition anymore, and you were getting on it.
No,
and,
I'm following the code.
Okay.
It's based off, seriously, it's based off of substantial evidence and the testimony. And I haven't heard any testimony at this point that says that we are not meeting the code. And that's what we have to base this decision on, because I'll tell you, if I base it off my feeling, I'd be instantly saying no. But we would instantly be appealed if we did that, because there has been no competent and substantial evidence that has said that this is not what we're supposed to do inside our code. And I haven't been doing text while I'm doing this. I've been actually studying our code as we've been having that testimony, because that's the village's code. And I'm in transfer of development rights, and I'm reading transfer of receiver sites and affordable units. And it's driving me crazy
Okay,
that I
Don-
can't find it.
To Don, our staff's recommended this,
Yes,
and
sir.
our attorney just told us what it was.
Yes, sir. I get it.
I do too. It's
I'm not-
fine.
I'm not happy
You
about
guys
it,
can-
but
you
it's
got
in
the
our code.
majority. I understand. I mean, I'm not being difficult. I just,
Okay, do we have a motion?
No, but I'll make one unless you want to.
Go ahead.
Okay, I'll make a motion to approve the major conditional use in K as presented. But I want to put a caveat that I hope you're hearing what we're saying
I am hearing it. I'm hearing.
very loudly.
And we'll come back with that buffer
Okay.
again, because they've been committed to that.
Okay, so I made a motion to approve the major conditional as presented.
do I have a second?
One of you. Just
All right, I'll make a second.
Marnie, call the roll, please.
Councilmember Deb Gillis,
Yes.
Councilmember Buddy Pinder,
Yes.
Councilmember Steve Friedman,
No.
Vice Mayor Don Horton,
Yes.
and Mayor Sharon Mahoney.
No.
It passes 3-2.
All right,
Okay, the third one
guess
is,
you just took it over. Go ahead. Go ahead.
okay, is L, correct? Tab
Yes,
L.
yes, that's correct.
And it's on the transfer of development rights. I make a motion to approve the transfer of development rights from Creekside to Islander Resort as presented.
Do I have a second?
A second.
I made the motion.
Did you make a motion?
Yeah.
Yes.
You did, okay. Marnie, would you call the roll, please?
Councilmember Deb Gillis,
Yes.
Vice Mayor Don Horton,
Yes.
Councilmember Steve Friedman,
No.
Councilmember Buddy Pinder,
Yes.
and Mayor Sharon Mahoney.
No.
That passes 3-2.
Okay.
Thank you. I'll see you in a
Alrighty.
month. And we'll get that language. I know.
And also, please make sure you do something for Carroll Street, if that can be included, please.
We already did that,
Thank
but what
you.
we're gonna add in is a
Okay.
buffer. I'm gonna get that to staff, so we have it,
I
like,
appreciate that.
the width of it. We'll get your votes next time.
Yeah.
Maybe.
Yeah.
I'm gonna.
Yeah, Bart, we
I'm gonna
do
figure it out.
need to, because I know that Dave, there was a lot of issues with Mr.
And we
Curry.
get it, and you guys know Zoysia and
Thank you.
Clusia, that stuff is gonna be so thick. I got it in front of my house, you can't see it from a mile away, so.
Thank you very much.
Thank you, I appreciate your time tonight, thank you.
All right, anything else this evening? No? First, before we go, I'd like to wish everybody a very Merry Christmas and a Happy New Year. And take care of each other and take care of yourself. Thank you.
Happy
Meeting adjourned.
holidays.